recommends you to receive help from the places listed above, despite what the DHS may tell you. A copy of the summons and complaint are sufficient, and you've already received that. You may be able to reach an agreement with the landlord by going through community dispute resolution. So far, that's never happened either, but it might, and if both parties are interested, we can help set that up. You may be able to reach an agreement with the landlord that means the case would be dismissed, in which case we would assist you in filing, or the attorney would file what's known as a conditional order of dismissal. The first matter we're going to take up is V squared versus Hively and others. Natasha Hively is here. Carissa Finneman-Rarick is here on behalf of V squared, and John Bush is representing them.
Kim just took this message at 9:10 EST Monday.
All right, Gary Coy was in for a brief second. Am I supposed to call this guy?
Yes.
Okay.
Actually, Roberta Coy is here too, but I put her in too soon,
Put her in where?
the conference room, because Rachel Harris, the 9:10 one.
Why don't you? All right, why don't you bring her in here?
Bring her in here?
Mhm.
Okay, will do.
All right. This is filed as a demand for non-payment of rent. This is a new complex just on the edge of Centerville with 54 units in it. Is that correct?
Yes.
And the rents are about $1,000 a month. And I had expected once the place was up, we'd start to see cases from there. We haven't seen very many, but we're starting to see them. Also here, on the complaint, are Sarah Strout and Joseph Whitaker. Ms. Hively has a personal protection order against Joseph Whitaker, which is file number 25234PP, which prohibits Mr. Whitaker from coming to that address. And that order was issued by Judge Pattison in March. Well, the posture the case is in right now, it's a demand for non-payment of rent, that the rent is delinquent. Mr. Bush has provided me with a accounting sheet, which I greatly appreciate. At this point through August, Mr. Bush, you contend the rent arrearage is $3,000
Yes, sir.
with a $213 in cost, 67 cents, and $120 in late fees. Through August, the amount is $3,333.67. Is that correct?
Yes, Your Honor.
All right. Ms. Hively, you sent me a letter and set forth the background here, and I'm aware of the circumstances. I also got some other correspondence and some emails. But this is simply a matter of whether the rent is paid or not. At this point, they contend that your rent through August is $3,000, which means it hasn't been paid in June, July, or August. What's your position?
I sent you a copy of the payment history.
Yes.
I do believe it was paid in June. I'm not 100% sure, but
Well, you sent me this thing. it shows March, April, May, but it doesn't show June.
Okay. Well, here's the thing, Your Honor. I'm not opposed to non-payment. That's not where I had asked for a written early termination due to domestic violence because he would not leave the property and nobody was making him leave the property.
Well, it's not the landlord can make him leave the property with a legal action, but they can't just force him out. But theoretically, he was in violation of the PPO, and the sheriff should have been. So are you no longer there?
I left there in March, and then I asked in March, I sent you a screenshot of mine and her conversations where I asked for an early termination due to the events that were taking place and the abuse that was taking place. Because I could no longer stay there and nobody was forcing him out.
All right. Let's talk about this. So are you willing to just relinquish the unit? Do you have all your stuff out?
No, I ended up, I went there one day with the police officers. They still wouldn't make him leave even with the PPO order. I don't know why. They didn't give me an explanation. I was able to grab one carload of things and we fled to another state because he was threatening to kill me. But this eviction is going to cause problems for my future because nobody's going to want to rent to me because of his abuse and his choices and his decision. And I didn't have anybody supporting me to get away from him.
All right. So you're out, you're not living there, but all your stuff is still there?
Yeah, I just pretty much washed my hands of the whole situation. I don't want nothing to do with him. He was still there up until I guess the police officers made him leave. Yeah, I just don't want anything to do with that man or my belongings. I can start over. That's fine.
Sir?
Is he there?
Yes, I'm here right now.
All right. Well, you're late to your own party.
No, I've been trying to log in, but it wasn't working. Sir, she has charges.
Well, just a minute. Just a minute. Are you Joseph Whitaker?
I am, sir.
All right. I ask you to take your hat off.
Your Honor, I even have an email from Joseph Whitaker.
Stop. All right, Mr. Whitaker, are you still at this apartment? No, he's frozen. Mr. Whitaker,
Yes,
are you still living there at this address?
I am. Yes.
All right, well, you got to pay the rent. You owe $3,000 in rent, $213 in court costs, and $120 in late fees. So the total amount of rent due is $3,333.67.
I applied for the MDHHS, the SER, the SIR application. I'm just waiting to hear back.
All right. One of the problems is the personal protection order that's in effect prohibits you from being at 219 Venture Boulevard, Apartment 1. So you have a personal protection order in effect that says you're not supposed to live there.
It shouldn't be in effect anymore. I had went in and what is
It
it
still
called?
is, Your Honor.
No, it's not. No, it's not.
I called and made sure from the judge myself.
Stop. Mr. Whitaker, the order is in effect. You don't just call up and ask them to drop it. Judge Pattison orders that you not live there.
I didn't call. I actually went there. I even tried to serve her. I tried to serve her papers to go to court for that, and she never showed up.
All right. The PPO is in effect. You're not supposed to be living there, but she's not there. So I guess maybe it's not as important. I can't imagine they're going to give you money to pay your rent on a place that you're not supposed to be living at. But the law requires I adjourn this for 7 days.
Okay.
And then I'm going to tell you that you owe $3,333.67 by 10 days from next Friday, which would be the 25th of August. I'm sorry?
That was on her end. I don't know.
Yeah, Miss Hively, what did you want to say?
No, that wasn't me. I'm sorry.
Okay.
I was just letting
Anyway,
you- I was
Miss
trying to
Hively,
make sure-
you're out of there, so it's less crucial for you because you don't really care. If he doesn't pay the rent, he has to move out, and that's up to him. If
Well, I
we
had
get
to leave. I didn't have a choice. He wouldn't leave. I even have an email from him saying, "Please don't kick me out." That's why he ended up putting his hands on me. 'Cause
No,
wouldn't
I never
come
put
back.
her.
All
I
right,
never.
all right.
Shut up.
Stop,
Tasha.
stop. This isn't a PPO hearing. It's a non-payment of rent hearing.
Yeah.
And we're quite busy next Friday. 9:20, 10:30, 11.
Embarrassing.
John, you're gonna have several of these. How about if we continue this to 8:30 on Friday, August 15th? Does that work for you? Oh, that's the first, that's Judge Patterson's pretrial date.
Are you talking the 18th, Your Honor?
Yes, the 15th, Friday the 15th.
Okay, I have one already with you. I have one pretrial right now scheduled early that morning.
What-
And I think
what
I have
time?
something.
Which case do you have with me?
I don't know. I think it's set about 10:30.
Memory Lane at 10:30.
Mhm.
Let's set this for 10:40
That should work.
on August 15th. All right, Miss Hively,
Yes, sir.
you're also welcome to be here. I'm going to tell him that the rent has to be paid or he's subject to being evicted. It's unlikely he's going to get emergency financial assistance for a house he's not supposed to be in. But we'll see where that goes. If the rent is paid, then you get to stay. If the rent is not paid, then he's going to have to move out by August 25th or be subject to being evicted. But we will revisit this entire matter next Friday at 10:40.
Your Honor, can we make any, where is Sarah Stout, the other defendant?
Yeah, where is Sarah Stout?
I'm here.
All right, who is she?
She's named in the complaint.
Yeah, how are you related to this, Miss Stout?
She
I
was
was on
my
the-
roommate.
All right, so she's with Natasha. And
Your
she
Honor,
was
for
also,
a minute, can I say something as well?
yes,
Sarah moved Joseph in. Joseph is never even on the lease. We rented to Tasha and Sarah. I didn't move.
I moved in the same time they did. We
No,
all
he
moved
wasn't
together.
welcome there, Your Honor, and I have proof of it if you need it.
Stop lying, dude. You gave me the house key. You gave me the house key. Stop lying.
all right.
Your Honor, like I said, I have proof if you need it.
Oh, yes, and I do too. God.
Well, let's take a look at the lease. Well,
I
anyway,
actually moved in before they did, to be honest with you, a week before they did.
well, you're not on the lease.
Well, I didn't
And
know
you're
that.
not supposed to, you're not on the lease and you're not supposed to be there pursuant to a personal protection order.
I went
They're
to
not
court-
going to give you any financial assistance to live there. You're not on the lease. So
I went to court for that PP order. I don't know why it's saying
you
it's
didn't
active.
go to court. It hasn't been dismissed.
It should have been.
Well, perhaps, but it has not been. He's not on the lease. So I don't know what the deal is, but somebody's got to pay the rent. And Natasha and Sarah are not going to pay it. So my advice to you, Mr. Whitaker, is you find another place to move to, because I'm going to give you 10 days from next Friday to move. They're not going to give you any emergency financial assistance for a property on which you're not on the lease. So, all right, we'll address this further next Friday. That took
Your
us
Honor,
much.
I have a question. This is
Yes?
Natasha. Is this eviction going to be on my record?
It will be unless we otherwise resolve it.
So due to no fault of my own and nobody making him leave, it's going to be on my record.
Hey, take responsibility, doctor.
I'm gonna mute him. Yes. Nobody put you in a relationship with him. I'm not sure what happened, and I don't know why.
No. I wasn't in a relationship with him. I'm trying to tell you. I have an email from him telling him not to kick him out, and I told him he was never welcome in the first place. Sarah had a relationship with him.
All right.
Her and I had an agreement he was not
All
supposed
right,
to be
well,
there.
then
He was not welcome
that's
there.
on you guys, but yes, it will go on your record unless it's somehow otherwise resolved. So I'll see you next Friday at 10:40.
Your Honor, do I need to be here too?
Are you Sarah?
Yes, I am Sarah.
Oh, I didn't realize you were, yes, you're welcome to be there too, Sarah. So you were in the relationship with Joseph?
Yes,
All right, this is even more complicated than I thought. I thought she was. Yes, but as far as I can see, you don't want to come back there anyway. So yes,
no.
you should
I
all
left.
come back. All right, thank you. I'll remove you as well. So Sarah was here. She was not properly named. I didn't know who she was. All right, we're off like a herd of turtles. Mr. Whitaker, I'm going to remove you also and send you into the great wide open. Let's bring in Meg Bauer. And somebody named Samsung, which is an actual name. Good morning, Meg.
Good morning, Meg.
Good morning, Judge. Good morning, John. Sorry, I missed.
You missed a lot of fun so far. We had a couple of unruly defendants. And I've got people that are having trouble logging in. Samsung has just come in. Who am I speaking with? Samsung phone. Who am I speaking with? I would live 3 years longer if I didn't spend this much of my time asking people who they were. Samsung phone. Who am I speaking with? I don't know. All right, then I got a couple other people. John, your client, Mr. Pearson's having trouble logging in, so I'm gonna send him an email invitation. I don't know, he's been in here before. I'm not sure what happened. Further, oh boy, make things interesting. I theoretically got a bunch of criminal cases at 10 o'clock. We're not going to be there. But let me try this again. All right, and I've got some other guy who can't log in, Adam Stevens.
That's the 910 case, Your Honor.
Yes.
Please.
The number you have dialed is not in service.
No.
Check the number and
Hello,
Hello?
this is Eric Pearson. Can you hear me?
Yes, Mr. Pearson. Yes, I sent you an invitation and you apparently clicked on it. So I got Mr. Stevens, who his phone number doesn't work. Let me try this again. All these things diminish our efficiency.
I apologize for being a problem, Your Honor.
Oh, it's all right. We're used to it. Bumps in the road. Good morning. Is this Adam Stevens?
Yes, sir.
All right, this is Judge Middleton. This is file number 251410LT. Mr. Stevens, you're a defendant in the landlord-tenant proceeding. You're late, and I was able to call you and make this connection.
Yes, sir.
I've also got some other people who I'm going to bring in here. Kevin Griffin is here. Rachel Harris is here. What's your name, ma'am? Ma'am, here in the court?
Susie?
Roberta, what's your last name?
Coy, C-O-Y.
All right. I had Gary Coy on for just a blip. All right. For all the others that are here for landlord-tenant case, I'll go through this again. As a defendant in landlord-tenant proceeding, you have the right to have legal representation. If you cannot afford an attorney, a legal aid attorney may be available to help you. It's not guaranteed, but Attorney Megan Bauer is here from Legal Aid on the feed this morning and watching the proceedings. You have a right to a trial by a jury or by the court. If you wish to have a jury trial, you must tell me at this first appearance or file a written demand within 5 days, and either way be prepared to pay the $50 jury demand fee unless the court waives it for your inability to pay. You have a right to have the case heard here in St. Joseph County where the property is located. If the plaintiff is agreeable and both parties would like to have their matter referred for mediation, the court can do that. Help set it up. If you reach an agreement with the plaintiff, that means a consent judgment is entered. We could enter what's called a conditional order of dismissal. So we started out with a bumpy road and we're still on it. So let's talk to our next case, which is V Squared Ventures versus Rachel Harris and Adam Stevens. Rachel Harris is here in the conference room and Adam Stevens is here by telephone. Let me make a note here. And Carissa Finnerman-Rarick of the V Squared is present. And Rachel Harris in conference room. Mr. Bush has provided me with an accounting breakdown of what he alleges the arrearage to be. These units are renting for $1,000 a month, June, July, and August, plus late fees of $120 plus court costs is $3,389. Mr. Bush, is that correct?
Those numbers are correct as far as I know, Your Honor.
All right. Ms. Harris, are you still there?
Yes, I am.
And Mr. Stevens, you're gone?
I'm still at the address.
Oh, okay. So are you both living there?
Yes, Your Honor.
At the current time, yes, sir.
But you're split up?
Yes.
Oh, we're not together, yes. We've been as known as roommates at the current time.
Well, Mr. Stevens, you could have just come to the courthouse. You're only a quarter of a mile away rather than have me call you on a neighbor's telephone. Well, you guys either have to pay the rent or move out. What's your position?
I haven't got a drink. Go ahead, Adam.
Just a minute, Ms. Harris, you go first.
I have a job interview on the 11th at 2:00. I had lost my current job when I had moved into this village. And my understanding was Keystone was paying my rent.
Well, now nobody's paying it. I had expected to get lots of cases. I didn't know Keystone was paying some of these, $1,000 a month for those small units. They were all immediately filled, but $1,000 a month is a lot for our folks. Maybe not in the greater world, but Keystone's not paying your rent, and neither is Mr. Harris or Mr. Stevens. So I'm going to continue this matter to next Friday, August 15th at 10:45.
Okay.
And if you get some emergency assistance, it can help. You have to pay the entire amount. Payment of partial payment will not prevent the writ of eviction. So you have to pay the whole thing. If you can't pay it, you're subject to being evicted within 10 days after the hearing next week. So you have essentially until August 25th to pay the rent, late fees, and court costs, or subject to being evicted. But we will address this further. Mr. Stevens, if you can't get here, you come to the courthouse. I don't want to do this by telephone. Ms. Harris is here. She just made it down the street. So I don't want to do it by phone. So I either do it by Zoom or live next Friday at 10:45 a.m. Ms. Harris, did you say you did ask for help?
Yes, I did. I did a CR form. I got denied of that, and I also got a little legal aid.
All right, let's just say, for example, they'll pay your half of the rent. Well, that won't fix it. You have to pay the whole rent. It's $1,000 a month. So I'm not sure. Mr. Stevens, do you have any source of income?
Off and on, yes, sir. But I'm also in the meantime of trying to get some assistance from a couple of gentlemen that I know myself, and also I also wanted to put it out there. In the process of us staying here, why Keystone was paying our rent for us before they stopped, we had a complaint, I guess, as a small eviction of supposedly smoking cigarettes and marijuana inside the apartment. That was our first eviction towards me. Well, how come we're only ones getting complained about when 95% of the apartments do it here?
I don't know the answer to that. It's in your lease.
Then there was another complaint supposedly about somebody breaking into one of the apartments here using the bathroom floor number 2, and I got asked to lift up one of my shoes from one of the maintenance workers, and I said, "Here you go." I said, "What's going on?" He said, "Well, we had somebody, I guess, got one of the."
All right. Well, you're telling me more than I really want to know. So we'll address this next Friday at 10:45. You guys have either got to pay the rent or be subject to being evicted. I didn't know Keystone was going to get involved in these. That's a recipe for disaster, because they're going to pay a couple months rent, and then the money's going to run out, and the people won't be able to afford $1,000 a month. But I guess we'll cross that bridge when we get to it. I will see you next Friday at 10:45, either by Zoom or live. All right, and hopefully you can get some emergency help and help get caught up on it. All right, Mr. Stevens, I'm going to hang up on you. Thank you. I'll see you next week. All right, Miss Harris, you're good to go.
Thank you, Your Honor.
All right, we've only made it through 2 cases. We're like going at a turtle rate. So Fenrick, well, our first case didn't show up. So let's address that one, which is Fenrick versus Amy White. That is file number 251408. This is an apartment in White Pigeon. No service. Defendant was personally served and she's not here.
We would
Sir
ask for
John.
default judgment, Your Honor.
All right. In this case, rent through August is 2008. Miss Finneman Rarick, is she still there?
She is.
Your Honor, it's a weekly rent, so the number is through the second week of August in our chart.
All right, August 15th. $181.20 in court costs for a total of $3,201.20. That is due within 10 days from today, which is 8/18. Partial payment will not prevent the writ of eviction. No money judgment is entered at this time. All right, let me make a note here.
I've got it right here, Your Honor.
Oh,
We approached.
Good. Do I have an option on that?
I'm walking, you can just.
Yeah, come on.
An option.
Come on up.
It's right here.
Thank you very much.
Good morning, Your Honor.
Good
I
morning
walked
to
out.
everyone.
I did grab. Oh, I didn't. grab-
Okay, on the bond forfeiture docket this morning, Odwin Samuel to have all the bond forfeiture here today.
Would you come represent all these people, please?
No, he's not. That's not him.
Not him. Oh, okay.
Not him.
Thank you, sir.
Okay. When the first case we're going to call on this bond forfeiture is Nisi case number 24 DCCV 1390. The defendant is Jose Betancourt Vega. That's a familiar name, and surety is Keith Day. And this is criminal case number 24 CR 611. The bond amount was $6,000. And Nisi was filed on August 1st. Apparently, the defendant was rearrested about 3 weeks later on 8/20/24. So we have a bond amount of $6,000, court costs of $358, and interest in the amount of $18.74. And the bondsman is Gail Lilleman. And is any of the parties or any of those parties we mentioned here? No response. And they get notice of this. And generally they don't unless there's an issue that they have. They don't show up.
Right.
Generally, unless there's an issue. So what is the state asking as there is no response to that called case and name with the surety and the bondsman mentioned in the record? What is the state request?
Your Honor, the state would request that the court take judicial notice of the court's file in both the Nisi case and the criminal case.
It shall.
And based on that, we would ask that the court enter judgment in this case for court costs and interest.
Okay, bond amount 6,000 is, we don't worry about that.
That's correct, Your Honor. That
Okay.
if they get them rearrested within 270 days, then
It was
they
done
owe
in this case.
right.
Oh.
They owe court costs and interest.
Okay, so the court finds judgment of court costs of $358, interest $18.74 to that, and it goes to the bondsman in this case, right?
That's correct,
Is
yeah.
assess the assessment of costs and interest, and the court so finds that to be a proper and based upon the evidence in the record and is so ordered. Okay. And next case is criminal case number 23 CR 1518, Nisi case number 24 DCCV 1842. The defendant was Tarika Hawkins, and the surety was Gail Lilliman. And I guess there was Gail Lilliman is also the bondsman as well. And we have a Nisi file date of September 17th, about a year ago, 2024. But the defendant was rearrested 11 days later on September 28th of 2024. And the bond in that case was $7,500, but court costs are $350, interest $13.56. Gail Lilliman is called, and there is no answer in the courtroom. And what says the state of Texas?
Your Honor, the state would request that the court take judicial notice of both the criminal file and of the judgment Nisi file in this particular case.
It shall.
And Your Honor, we would ask that court enter judgment for court costs and interest in this matter.
And thus, based upon the evidence in the record here, court costs are assessed in this particular matter, $350. Interest is $13.56. And the surety is Gail Lilliman, and a judgment will be rendered reflecting those findings and decisions by the court. Next is Nisi case number 24 DCCV 1839, criminal case 23 CCR 1522. The defendant was Tarika Hawkins, surety Derek Haynes. And defendant Octavio Hernandez Pluma, cash bond. We got two defendants.
That
one
goes with the next.
Tarika. Okay.
That's the cash bond is the next one.
Okay, I see the way it's not. Sorry. Yeah, that was kind of tricky.
Got me too, Your Honor.
All right. So the surety is Derek Haynes, and the defendant is Tarika Hawkins in this case. What says the state?
Your Honor, the state would request that the court take judicial notice of both the underlying criminal case, the court's file in the underlying criminal case, and of the judgment Nisi case.
It shall.
All right, and we'd ask that the court enter judgment for court cost plus interest in this matter.
Tarika Hawkins, Derek Haynes. There is no answer. Derek Haynes is absent on this and has been given due notice to be present. And the court thus shall assess court costs in the amount of $350, interest in the amount of $13.56 in this case, and finding that it is just and based upon the evidence presented, and a judgment shall be entered in that regard. The next is a defendant named Octavio Hernandez Pluma with a cash bond in Nisi case number 24 DCCV 1386, criminal cause number 23 DCCR 2251. The defendant was Octavio Hernandez Pluma. In this case, Nisi was filed on July 31st of 2024. The bond amount was $5,000. Court cost $358. And then we have no arrest. The defendant is still an absconded.
Correct, Your Honor.
Okay. And the bondsman in this case is Al Reed.
No, in this.
I thought it said no. He's on the next case.
That's correct. No, this is a cash bond. So
okay.
The defendant is actually his own bondsman.
Okay. So what is the state requesting? And again, Octavio Hernandez Pluma, there is no answer here in the courtroom. He has failed to appear.
Your Honor, the state would request that the court take judicial notice of both the underlying criminal case and of the judgment Nisi case in this matter.
Yes.
And enter judgment for court cost plus the full amount of the bond in $5,000.
And the court finds it is just based upon the evidence presented and the record, which shows that defendant Octavio Hernandez Pluma shall be assessed the amount of bond $5,000, which has been forfeited, court costs in the amount of $358 for his failure to honor his commitment on the bond. And that judgment shall be rendered based upon the evidence presented, which justifies that assessment. Finally, Al Reed is the next bondsman here. The defendant was John Walter Bordash Jr. in EC case number 24 DCCV 1388. Criminal cause number 23 DCCR 1439. And the bond amount was $20,000. Court costs $358. Interest is $608.22. Apparently, a Nisi file date occurred a little over a year ago on July 8th, 2024. The defendant was rearrested approximately 6 months later on January 31st, 2025. And Al Reed is not present, and neither is defendant John Bordash, not present. What says the state of Texas?
Your Honor, the state would request that the court take judicial notice of the underlying criminal case and of the judgment Nisi case in this matter.
It shall.
And enter judgment for court cost of $358 and interest of $608.
All right, the court does, will follow the state's recommendation and request, and will order court costs in this particular matter in the amount of $358 with interest of $608.22 in this matter involving the surety Al Reed in the case of the defendant John Walter Bordash Jr. It is based upon the evidence and the information that the court has been provided in this particular case. Anything else?
Your Honor, those are judgments to formalize the entry for each one of them that we just went over, Your Honor. Oh, okay. Oh, thank you, Your Honor. Can we take these?
I'll take them.
Okay. We got to go over there again.
Okay, I've signed these. What I'm noting here is I'm signing this just for the clarification of the record. I'm signing on the line that says Judge Presiding. Actually, that's not my last name, Presiding. People have asked me, I got this thing signed by you and it says Judge Presiding. Why didn't Judge Presiding sign this? I go, well, I guess we can't find that one.
Your Honor, we have one other matter if the court would have just a moment to address it. It'll be really quick.
You always got the best for last. Thank you.
It's an amended judgment Nisi. The original judgment Nisi had the wrong bondsman on it. So we need to amend the judgment Nisi in order to identify the correct bondsman so that we can get service process done and move forward with that case.
And this is cause number 25 DCCR 255 and facius number 25 DCCB 1077, the state of Texas versus David Tizino, and the bondsman was Lexington National Insurance Company. And is anybody here present that contests this request by the state? Nothing present. Nobody present. No information is provided that suggests that the court should not grant the state's request, and therefore I'm signing this to correct the earlier judgment. And this amended Nisi judgment Nisi is signed this 8th day of August of this year. by Judge John presiding. It's always been that way.
There you go. Thank you, Your Honor. May we be
Yes, sir.
excused?
Thank you very much. Thank you. All right, let's get to Sarah Burnett. First, David, are you ready on that, or you want me to? Are you ready? Or do you, I can come back to you if you want, because you got a bunch of stuff here, looks like. Sarah Burnett, that you, man? Oh. Okay, this, I'm looking at this, it says status, held in abeyance, restitution. Two cases, so we've got 13-17581 and 15-21605. Sarah Eugenia Burnett is you, that's you. And there are first amended motions to revoke probation that were both filed on February 14th, 2025. I don't see any action taken on these, right? This is our first appearance on this? No, what did we do before? Because I didn't make any marks on the documents, which I normally do when I hold a hearing and then make findings. Did I just postpone everything to see how she was going to do? Because one of these is a drug matter, and the other was arrearages in an astronomical amount. Restitution is.
I believe, Judge, this is a long time ago. I believe it was in 2023. She didn't show up for a hearing on time or something like that, but that's been a long time ago.
But
as of right now, I believe we're just reviewing to see how she's doing before.
Yes, Your Honor. That's what I had from March 20th is reset to review payment status.
I'm looking at, okay, let's see, on 17581, the first amended motion to revoke probation. What is the restitution owed on that? On in 17581.
The balance is $125,356.
125,000, what? How much?
$125,356.
I want just to note on the, and then the other list of on the first amended motion, there's a mistake here on page 1 of the motion at the bottom where it states restitution. We got to correct that. It's showing, well, it's showing the numbers,
yes,
but the comma is in the wrong place. So we're going to just correct that without objection.
Yes.
I'm not sure where I'm not following where the court is.
There is no such numerical equation for 13,1608.
Oh, I see. Yes, sir. Okay. I'm sorry. I wasn't following.
Well, we don't, yeah. So I'm correcting it. You put the comma in the right place to reflect at that point in time when it was filed, it was $131,608. I'm correcting. Any objection on the forms? So going to, I'm gonna hold that one in advance in 15-21605. What are we doing on, what's the arrearages as to that?
For restitution is $10,244.95.
These were both filed 6 months ago.
Right.
These motions. And so in the last 6 months, can we do the math real quick? How much she's paid in the last?
Largest, it's roughly 12,000, I believe. 1,200. I'm sorry, not 12,000. There are 1, 2, 3, 4, 5, 6. She has been paying conditions. 2, 4, 6, 8. Yeah, about $1,200.
A month?
No.
Go ahead. Can you explain why it's not better? Yeah.
Well, at our last hearing, I told you that I could pay 300 a month. And so that's what I've been trying to do.
Okay, which ends up coming at 200 a month. You know, I mean, we can do the math. It's 2,400 a year for these, which would take 60 years to pay. You can see that's impossible. So what do we do about it? Does anybody have ideas? We try to make it work. I mean, we have a victim here. You were close, you know, on probation, as you know. But this isn't, the restitution was astronomical in both cases. And really in one case was overwhelming. And another case was also 5 figures. So we don't have any more drugs showing up, huh? Do we test her? You do test her? Okay. But I mean, it's 60 years. How do we? So has your income changed?
But if it does.
I don't know. Well, how do you? What do you think of victim when a victim hears that? What do you think they think? Thanks. Gee. Whenever she gets around to it, okay, but that doesn't. They don't accept that. Each of these victims were business owners. One of them a car dealer, automobile.
Well, kind of both. One was a freight liner, big trucks, and ridiculous stuff.
What are the parties need to add anything? I'm gonna ask probation, how are things otherwise? But what I can't squeeze money out of something that is not squeezable. Well, I mean, we're doing the best we can. This is all I can ask. Where's your income from?
I am a housekeeper and a pet
System.
My business is growing
Ma'am?
steady. My business is growing steady, but not to the place where I can.
Pay more.
Yes, sir. And I'm often trying to get
Yes,
customers.
Oh, you believe that? Oh, okay. Well, the court really didn't have much option because I just expect pay what you can. If you can't exceed 200, we're going to just continue to keep that amount and then review in 6 months. Anything else to add by anybody?
None from the stage, Your Honor. No, Your Honor.
Okay, then that's what we'll do. Reset for 6 months for review. Thank you.
Thank you.
And the news is different.
Yes, sir. He's currently enrolled in the A.
What they go to 22 39246 to review of status, I think, on this motion to revoke probation that's pending. Mr. Champ is, that door's locked. And you are Jose Cortez with Mr. Samuel, your attorney and the state's attorney. And where are we on this?
I think we're good. Good morning, Your Honor.
Yes, sir. Good to see you.
We're in a good place. That's a good thing.
I mean,
He's currently
often the news is different.
Yes, sir. He's currently enrolled in the ABC school.
The what?
ABC School Associate Builders Contractors. And he completed the GED on May 22nd as requested. He's current with his fees. He's got
Make a good grade. Good.
So I'm
Education
pleased.
is a key to everything, making better decisions in life.
Yes, sir.
So I'm good. I'm glad. What do we want to do then today? Review in another 6 months?
That sounds good.
What do you think?
I think that's.
Says we can, if all is well, I guess we can shorten this in a third, but we're not there yet. But
I think we'll get there. So.
all right. Well, don't fall off the track. Seems like you're in the right direction. Like 6 months, we'll review it again. Keep doing well.
Yes, sir.
Yes, sir.
Oh, thank you, Your Honor.
Thank you.
Thank you, Mr. Chairman. Appreciate it.
Cap.
I'll just email you those for that. I already have the sets in here. And if I, for some reason I didn't have. Well, so I'll just email you those.
Did you have the Catherine Furlough file or did I?
They all should be here.
But no, the next one is John Gilbo, which is
Furlough was reset, Judge.
Furlough was reset.
Furlough was reset.
Yeah, I didn't see. It's not. We can fix it. John Gilbo. John Arthur Gilbo, please. It's not done.
I'll pass it on the next one.
Probation review. ISP aftercare review. All right, and you are John Gilbo?
Yes, sir.
Present, and probation officer is here. Thank you very much for being here. What is the status on Mr. Gilbo? Good, bad, or?
He's in the JCDI program. He's making all of the requirements, going to cognitive groups, going to AA, His drug tests have been negative for the most part.
That's not the right answer. For the most part.
One,
Was this the one?
positive in April for alcohol,
Okay.
where,
We had a drug positive in December of 23. I don't want to see that again.
yes, so prior to ISF, I mean, he was positive, and then since being out of ISF, he's had one for alcohol, and that was in April.
What are we doing about employment income?
So I was going to school. I just finished CDL school.
So you just finished which school?
CDL school.
Okay, that means.
I just got my CDL. I took my test Tuesday. I go pick my CDL up today.
What do those letters mean?
Oh, it's commercial driving.
Commercial driving.
Yeah. I drop trucks.
So what's the opportunities there? Pretty good?
Yeah, pretty good. I have some job interviews lined up. I have one with TNA, which is a dump truck company next week. And then I've applied for other jobs like FC Cisco. So just waiting. I just finished school this week.
Okay, you're on deferred or unadjudicated probation, so you're not found guilty of anything.
Yes, sir.
Don't foul that up. Yeah, yeah. That was a gift that you don't want to lose. So make the most out of that. And make a good career out of it if you can. So today, let's see. Is he still on an intermediate sanctions treatment track? Or
No,
did
he
we do that?
completed ISF,
Okay, we took care of that.
I believe.
Yeah, that was last year. Was the last administrative hearing that I have a copy of. So, all right. So, sounds like he's doing fine. What do you want me to do now? Is it review in 6 months?
With that.
What do you think? Or is it necessary?
I honestly don't feel like it's necessary. If he has any additional violations, I can send a memo in
I
or.
want to see that. Okay, good. Good. All right. All right. Do well and prosper. Okay.
Thank you.
Thank you,
Are
sir.
we dismissing the MPRP?
Or are we dismissing the MCRP?
The recommendation of the MPRP was ISF, and he completed ISF.
Let's do it.
We'll follow him.
Okay, get it off his back.
No, thank
Okay.
you. Yeah, good morning.
Yes. I have Jasmine Holloway next in clause number 21-38572. And you were Jasmine Holloway?
Yes.
And probation officer and prosecutor are here in this matter. The motion that was filed May a year ago, and I think what happened, did we send her to safety?
Yes.
Yeah, and then a substance abuse felony punishment facility aftercare review status here to make sure that all is well. And that whatever was taught there at that program that we're utilizing to be a better person and to successfully complete probation here. So where?
She's doing good. She's in supportive outpatient right now, attending class twice a week. Her drug tests all came back negative, and she's employed. She keeps us well informed of what she's doing, so she's doing really good.
Ms. Holloway, what do you want to say? Anything? No, how do you feel you're doing?
I feel like I'm doing good.
How many children?
4.
Four. What's the best gift you can give to a child, your child? The best gift,
Well,
sir, ma'am?
I said,
Love, okay, yeah, oh, that's good. Practically speaking, though, I've heard this and I believe it wholeheartedly. The best gift you can give your child is a good example. Because they're going to do what you do. You're the biggest impression to your child. That's for everybody. Parents are most impressionable to children. It's the way our Creator made nature and children. But you had made some mistakes here. You're fixing it. Everybody makes them. It's how you deal with the mistake. That is the real test of character. So we all make mistakes. Fix it. Provide the best example for your child so that they don't say, well, I'm going to do what mom did. And then everything seems to fall in place. And you got several children there, so good. You've got a bunch of folks who are you're going to make an impact on in their life by how you conduct yourself. So sounds like you're well on the way, and that if there's a problem, there's your lifeline. Probation office, if you ever have a question about a decision you're going to make, a choice, and you're a little confused about it or conflicted, call the lifeguard. They'll save you because they know how to fix and help make a decision. That's the right decision if you're having problems with it. So there's no excuse. You're uncertain, get help. Okay. So we've got you on probation for 5 years since February 2022. So we'll be in this February, it'll be 4 years.
She has 2 cases.
She has 2. No, yeah, this other one, huh? No, that one. Just this, the only one that was here before. So which one is that?
That's all on the peace officer.
It's all on piece. What's 10 over 10 or?
Yeah.
Okay. Same time?
No, it was 2 different cases, but a different one. It was 2008, and this was a 22.
Okay. What were in that first case? Ended up making a bad choice and getting that second case. All that's fixed, and we're well on the right track. Would you say, man? You're the best judge of you. Yeah. You know that. You think you got a grip on things. Good. Well, again, that's good. A lot of people come in here confused and act as though they don't understand what is clearly a right place. You sound like you've got good guidance and you got your head on straight, and you've got a lot of dependents who require you to make good choices. So be a good mom and a good professional. We'll review this in 6 months, see how she is doing. Okay. Anything you need to help you continue to do well? No, you're independent. Good girl. Thank you. Keep up the yes, miss.
Ma'am, I need you to sign this in a minute.
Wait, Mark Thibodeau? 22-40899.
It's not right there by the expo.
Anyone from there?
Yeah.
And you are Mark Thibodeau. You're on probation in 2 cases, and this was a shock probation status in each of these cases when you were sent to prison, and then we give you another chance. So, and that was back in 23. So how are we doing on ours? Are you making the most out of your chance?
70%
August 1st, I celebrated a year of freedom. So, I'm doing everything that I have to do to not go back down that road. So,
And probation, anything we need, act on or look into?
In addition to his 1 year of being out of incarceration, he's also maintained sobriety. We have not had any cognitive urine analysis. He is attending counseling classes as required. He has one more to attend, and he'll complete that. That program. I spoke with Mr. Kibito last night, and he feels that he is on the right track to successfully complete his probation and be a productive member of society. Ms. Simon, the supervising officer, would like to, once he completes his counseling, would like to have him removed from her specialized caseload and placed on the regular felony caseload. So that's a good thing.
When might that have a window of opportunity? When will we be able to get to that stage?
I'm on my last book in therapy right now. So,
Okay.
12 chapters.
Okay, but what does that mean? How
So,
long?
like, probably 6 months, maybe.
Okay, well, let's
because I
review it in
usually
6
do, like,
months.
2 or 3 chapters a month. So,
Yes, sir. Well, let's review it in 6 months, and then if he's doing well, then we can switch gears.
Yes, sir.
Where are you working?
I have a new job. I work for American Airboat Corporation.
What are y'all doing?
I build and fabricate airboats for the military.
Is that here in Beaumont?
No, sir, it's in Orange.
Oh.
I live in Orange.
Good contract?
Oh, yeah.
Oh, good.
Yeah, we're busy.
Good for you. Okay, that sounds great. What do you make an hour?
25.
Hello.
Yes, sir.
Well, I say paid me.
No, I mean, it can always be better. So,
It would always be better.
yes, sir.
I mean, but that's a fortune for most people.
Oh, I know. Yes, sir.
Because you're talking 60,000
Yes, sir.
plus. Anything else? You feel like you need to say or request to ensure that this gets completed?
No, sir. I make time.
Just
Just keep
keep-
important stuff first.
Good for you.
Yes, sir.
Good for you. Good maturity. All right. We'll see you in 6 months.
Yes, sir.
Yes, sir. Thank you. Thanks for being for here. It's Mr. Kittleball. Joseph Ledad. Mr. Ledad. Is next called in 11-10879. There is no answer in the courtroom. I ask the bailiff to call into the hall for Joseph Clarence Ledad. Anybody here from? Did we think he was going to be here or not?
I talked to him yesterday and he has a doctor's appointment this morning, but he said he would be.
What time was his doctor?
I believe it was at 8:30.
Where was it? Here in Beaumont?
I believe so. He had to get his dressing changed.
All right, we'll go. Can you stand by and we'll call him back here in a little bit. I'll need some more files, please. Valerie Lebanon.
Here's the rest, Judge.
Thank you. I know I mispronounced that, didn't I? Well, it's not Lebanon, it's Levina.
Yes.
Yeah. Okay, the defendant is present here in 15-21647. Probation office is present. Thank you for working on this case and.
It's review on restitution.
Right, how are we doing on that?
She's doing good. She's made all of her payments this year thus far. She has $23,035 left.
To pay?
Yes, sir.
But it was almost twice that at one time. 59,000
Yes, sir.
at one time. And we've reduced it to 23.
Yes, sir.
Yes. So how much are you paying a month?
$650.
How's that working?
It's
tight,
tight, but yeah.
But you're getting it
I
done.
gotta do it.
Yes, ma'am.
I don't have a choice.
Okay. The other, we had some other issues about reporting and community service hours, but everything fine?
Yes, so she completed everything. Her case actually expired in June. The motion to revoke is just keep holding it open. So she's not required to come in court.
Okay. Yeah, because it was an anniversary, 10 years, but the motion is still pending,
Yes, sir.
and that's what keeps it alive
Yes, sir.
for purpose. So are we gonna put her, do we, when this anniversary date,
June.
which has already happened?
Yes, so we put her in there.
So are we on an inactive
Yes, sir.
case? Okay, okay, good. It's less, we need to attend to the people who are having problems with their behavior. Those who don't. If it's money, we can just keep resetting in 6 months.
Yes, sir.
And we'll come back in 6 months, see how things are going. But you're well on your way towards eliminating that. And then you're on deferred or unadjudicated. See, it gets dismissed when it's paid. I mean, it's not like it's just you're terminated with a conviction. You hadn't been convicted. And you won't be as long as you keep up the good work. Okay. Get a resetting. Thank you, ma'am. Ashley Mack, please.
It's 6 months.
Yeah. Uh-huh. I have Ashley Nicole Mack,
Oh, just that was reset.
but that, I don't have a file. Okay.
Yeah, it was reset.
Jessica
On that.
Power. Motive Power. Jessica Power, Parra. In 12-14991. There is no answer to that name being called in the courtroom. I asked the bailiff to call into the hall for Jessica Parra. Who's probation on that one? Did we think she was not going to show?
Yes.
Oh. Don't scare us like that. We thought you were not here. That would have been disappointing. Jessica, present with the state's counsel and your probation officer. You have a motion to revoke probation that's been pending. This is a deferred or unadjudicated probation, which is the way you want to keep it. You don't want to get revoked and be convicted. And it was dealing with some conditions of probation, which included arrearages and restitution and costs and community service hours, which are all fixable.
Yes, sir.
So where are we on progress?
She's doing good. She's been making her monthly payments. We're down to 19,000.
You have a soft voice.
All right. We're down to 19,000, so she's doing good.
We are? Well, it was 53.
Mhm.
That's great. Boy, get that off your back. And then that will keep you from all other things being great, from being revoked and then convicted, and then you're back on your line. Independent, you know. And so how much are you paying a month?
500.
Okay, that's good for you?
Yes, sir.
Yeah. So again, the balance on restitution is how much?
19,330.
So at 500, you know, that's what, $6,000 a year. And how much again was the balance on restitution?
But at the beginning,
Right now, 20.
we're at 19,000.
19. Okay, so that's still 6 years, 3 years at this rate. But it's getting there. You're succeeding and progressing. Was this was food stamp? Fraud, is it food stamps?
Medicaid.
Okay, okay. All right, that's how you fix things. You just pay the loss back. Okay, it sounds like we don't really need to spend a lot of time. I'll see you back in 6 months, just to make sure all is well and we're in the right direction. Okay, thank you. Yes, thank you. Philip Parks. Philip Parks is next call, 17-28417.
Right here?
And
Or, no,
there's no answer in the courtroom. I asked the bailiff to call into the hall for Philip Parks. Did we think he was going to be here?
I saw.
Oh, he's out. And this one is administrative as well, huh? Oh. Is this about money?
Yes.
Oh, okay. And you are Mr. Parks, present with your probation officer is here and the state's counsel. Okay, how are we? I don't have anything. Updated this, he was ordered to pay a minimum of 300 per month. But where are we on trying to get to the bottom of this and complete everything? Because what do we have? Arrearages of how much right now?
34,124.55.
Okay, we really hadn't whittled it down much since 23.
Since the last court appearance in March, he's paid $500.
Okay. Oh, and the income source. What is it?
I have a job.
Doing what?
I'm a Boilermaker. It's actually we build heat exchangers.
Yes, sir.
For the plants.
Yes, sir.
Build and repair them. Yeah.
Is it full-time job?
Yes.
Well, how much an hour?
I make 26. I'm 26.
Okay, well, that's almost 60 grand a year. Pretty good. You gotta pay taxes and other insurance, things like that, but that's a fortune to a lot of people who come into this room. So how much are you paying a month toward all of this?
It's supposed to be 300. I haven't met that in the last, like she said, the last time we came, I've only been able to pay 500 due to medical conditions or whatever. But
how's that working? The medical thing getting behind you?
I still got a couple of operations to go through.
Do you have insurance?
Yes, sir. Yes, sir.
Okay. Good. But there's always a deductible.
Right. Co-pays and deductible.
Co-pay. Okay, so are we saying what you're paying now, is this the
Yeah,
best?
that's fine. That's fine. We keep it like that. I think it's gonna get better for me in the second.
Good. Well, you don't keep your job and keep your health,
Yes,
and
sir.
then it all works out. We'll see you back in 6 months. Okay,
Sure.
thank you. Yes. Elijah Savoy.
Yeah.
You're Mr. Savoy?
Sir?
You're Mr. Savoy?
Yes, sir.
Okay, and this is cause number 22-40439. There was no, I don't see a motion to revoke probation. This was kind of a on 10 years to further unadjudicated probation since 2022 for injury to an elderly person. And this looks like we have restitution was owed in the amount of about $14,000, wasn't it? And so this is one of those issues of me being a debt collector again, which happens in a lot of these cases. Where are we on this from probation?
Since we last appeared in court, he,
It was when? 6 months ago?
yes,
Looks like on 3/23, that March. Okay.
did it up for you. He been making the payments, he only gets one payment in May,
How much are the payments a month? He's,
$100 a month. He only missed one.
where are you working?
I'm not working.
Well, okay. What are you doing about that? Are you trying to get somewhere somehow?
No, sir. Like, if it was somewhere I could just like mow lawn and stuff, I'll do it, but I can't work.
Because you've got a disability.
Yes, sir.
All right.
He get disability.
What's a disability?
Oh, bipolar and stuff.
Who's the doctor?
I don't even know my doctor name.
He goes to spinal tap.
Yeah, I
Spinal tap.
Yes, sir.
So what do we think we ought to do here? He's making $100 a month payments?
Yes, sir.
That's the most you can do, you think?
Yes, sir.
No, ends up, being about 1,200 a year, which would, what's the amount of restitution here now?
$13,624.19.
And that's 10 years. I should live so long. But that's what happened. We gotta fix it. And sometimes it's one small step at a time, as long as it's in the right direction. Gets closer toward fixing it. Is there anything else we need to take up on him? Everything else is good?
Yes.
What do you think? Everything fine with you?
Yes, sir.
Okay. You're living where?
With my mama on Lexington,
Oh, okay. That's working out fine?
6550.
Yeah. You help her out?
Yes, sir.
In the house?
Yes, sir.
All right, good. All right. Well, we're gonna get you a little resetting. We'll see you back in 6 months, okay? So,
Yes, sir.
thank you. And any problems, always talk to your probation officer.
Yes, sir.
Your lifeline.
Yes, sir.
Okay. Natasha Siegel. We've been dealing with this one for a long time, huh? Since I was a teenager, actually. She missed that.
This one now? This one?
Yeah.
And yeah, this one's all about restitution and monies. So, excuse me. Where are we on all of this from probation?
Ms. Seals is making good progress, with meeting restitution payments.
Is everything frozen on this? She's not getting, is she hit with more
No, sir,
fees or
her
anything?
probation term expired in 21, so all of her payments are being,
Applied
to restitution. And
which is what balance now?
$17,852.50.
Well, that's less than half of what it was.
Yes, and she's been remitting substantial payments,
What monthly?
600, 500, $250. Once she remits the payments twice,
Okay.
so she's doing, I would give her credit because she does have some health issues, but she is remitting those payments. Yes, sir.
Well, look, just looking ahead, if you made $600 monthly payment, that ends up being 7,200 in a year paid back, and she owes 17,008.
Yes, sir.
So that could almost pay off in just a little more than 2 years, and that's at 600. So
I think she's saving her money to build it up so that when she does.
There's one big flat
Yes,
amount.
Yes,
When she
yes.
gets to a point where.
yes, yeah,
That's a
that's
way to
why
do it,
she's doing
too.
it twice a month sometimes to kind of.
Okay, but it's frozen and
Yes,
she's
sir.
whittling it down. It's not adding, we're not adding
No,
anything
sir.
to it. And it's just all a matter of money.
Yes, sir.
When's that little piggy bank gonna get opened? Do you think? You're paying, well, it's getting close. I mean, compared to what it was, you've done a great job. And I'd love to be at, see, yeah. Love to move on with this. When you can. Yeah, we'll celebrate. But we'll review it back in 6 months, okay? Another 6 months. And if any issues come up, make sure you talk to your lifeline. Thank you. Sabra Shivers or Shivers. In 21-37289. We have a first amended motion to revoke probation. It's been filed as of May, right?
Attorney, but she's not here. She
Yeah.
said that she can send all documentations.
You've it's alleging that you failed to report in March, the probation office provided a urine sample in May that had meth and amphetamine in your system, and also failed to report your new address, which didn't date it any.
I haven't heard. We sent something to the house.
Well, they don't just do it on whim. Something must have been returned.
Yeah, we got 2 returns mail.
Well, that's not good. What is it? Why is it being returned?
That's her proof of residency.
Okay, what does it say on the return? Did the post office send something? Or if they say she's moved, you got a problem.
I just gave her my lease and everything. It's in it's duplexes, so they might have tried to bring it to the wrong one. I'm not sure how.
Well, if it's duplexes, it's going to have a unique number to your unit.
But I haven't moved anywhere. I just got a new lease that I gave her the other day when I went to to probation. So I had to renew my lease for medicated.
What's it showing?
So we have return mail on the date of March 17th. I didn't notate when, but if you let me look in the file, I can go and pull it. And then there was another one on May 13th with the mail to return. There was also a probationer already out on the field visit. I asked them to pass by the house, and there were vehicles there. But in addition, she did show me a lease that on her phone, she tried to email it to me, but I wasn't able to receive it. I did get a number from the document. Everything was written in. I did try to contact the person that was on there. The number did not work.
I have her number.
Well, we punch it into the phone and it doesn't work. That doesn't really make a difference, does it?
The number you gave me on the new lease was for a man named James Matthews. The number didn't work.
I talked to Teresa Matthews. I don't know about him.
Yeah, you don't want me to catch you misleading the probation officer. It would be like misleading me, and that's catastrophic. That would be catastrophic to you, as you know. I mean, you're looking at up to 2 years in the state jail here. But we gotta be able to have contact with you. What are you gonna do about fixing this?
I do live there, though. I do.
That's not good enough. We gotta be able to contact you. Just the fact you do live there. You know, you've got to corroborate your word with proof somehow. And then we're sending mail, and the United States Postal Service is not getting it to you, which means we have. Do you want to report direct every day to the probation office? I could do that so we can keep up with you. If we're having a hard time reaching you, you don't want that, but you don't want that.
No, I don't want that.
Well, then you gotta fix this. We gotta be able to communicate and contact you. Um, the what are we doing on the drug stuff? Oh, we never had a hearing on this. This is just sitting here, right?
And she said that she's got an attorney she's hired, so we'll probably need to reset it a week or so to get that attorney to announce in.
Who is this?
Cedric Cowles, Cedric Cowles out of Houston. She said she could send y'all letter of representation or whatever y'all needed. But she had court in Houston today.
Well, can't send anything that's gotten into the file. Because we put it in the file for everybody. So what are we doing on this, this positive drug? What should we do? I'm gonna deal with that right now, somehow. What do we do?
To answer your question, I'd like to defer to the court, being that there are other issues.
Ma'am?
There are a totality of other issues. I was thinking about drop if you continue her probation today. But she does have some other things that are concerning. I've asked for documents from her to prove as to why she didn't come. She told me that she's not required to do that. That isn't.
Wait. You asked her to do what?
I asked her to provide documents. She said that she couldn't come to a drug test.
What?
I had went the day before, but my son was in the hospital. I called a CPS case. I wasn't aware that I had to give her the information on my CPS case.
Okay.
This is why I've hired an attorney, is because
I'm ordering you to do that.
Okay.
You can hire an attorney, but I'm ordering you. You disobey the order, you go to jail.
yes, sir.
Also, you don't want to come to drug test, then you are ordered to have a drug patch.
No,
No, that's what we're gonna do. No, it's not a debate. I'm gonna order you to have a drug patch and we'll be able to test you every day.
yes, sir.
That's a modified condition. Because this isn't a debate, we're not inviting you. It's orders of the courts. And when you're showing up methamphetamine positive, that's terrible. That's a big backslide. And we're going to do something to help you, but we're going to figure it out. You understand? So, but in this hesitating, when we order you to do something, you don't have a choice. As long as it's a reasonable order, which is whatever many other probationers have to follow, but it's not a debate. It's trying to help you get through this. And methamphetamine's a felony offense. Amphetamine's felony. You got it in your system. Illegal possession. On my watch, gee, that's not good.
When was the last time she was drug tested?
It's not a choice.
I attempted to drug test her at her last office visit, which
There's more to it than that. It's not just me choosing to do drugs. If you don't see my whole body, kind of stuckness I was until she gave me an out stuckness situation that I couldn't really get out of, or I didn't think that I could. So it's not just that I choose to do drugs.
So somebody's using, somebody's using drugs around you.
Not a choice. And I'll say that.
You're forced into it?
I'm forced into everything that I do. Do you
All
not
right.
see this?
But you gotta be forthright with this lady. I mean, if you need hold on.
Take you too long in probation. So
Ma'am, I'm sorry. What'd you say?
I have a broken nose from taking too long in probation the other day. So
How did you get that? I don't understand. Is somebody assaulting you?
She has said that she has been a part of an abusive relationship. She did let me know that on the 6th. She hasn't filed any.
Charges.
I did this time. I did this time. And I haven't left because I didn't know, I don't have anyone to go but back home, and that's not in this me, but she said that I can go back home. So I've set everything up for me to go back home to my family. Because she said that I didn't think I could leave the county. So I'm just stuck in Jefferson County because I'm on probation and I'm not from here.
What county?
Jasper.
No.
I've never had a problem with drugs. All the time I've been on probation, I've never had a negative drug test. I've never done any of
I
this.
know, but here's a big one.
And
This happened.
it's a choice. It's not my choice. I don't do.
But so you're under duress. I mean, somebody forced you into it? We're trying to help you.
I did ask her if she believed that he was going to take her life. She said no.
I don't think he's gonna kill me, no, because then that's not benefiting him. He doesn't get my check every week. He doesn't get.
What are we
I'm gonna.
What are we
go
doing to
home.
help her
Oh,
make her own choices so that?
I suggested that she.
I mean, but okay, what's preventing you from getting out of that relationship?
I don't have anywhere else to go
Nowhere.
other than home, and that's not in this county. And if I leave Jefferson County, then
So hold on. So if I allow you to go to Jasper County, how will that help you?
I won't be on drugs and I won't be getting my ass kicked because of every little thing that I do, and I'll be able to go to work and keep my own money and make my own payments.
Okay, what's wrong with that?
There's nothing wrong with it. Although I want to say that she did state that she has went home before and he came and got her.
No, I left. I never went home. I left. I went to a hotel and he come and found me. I went to my grandpa's and he come there, but I've never left him and went home.
Is your grandfather not living with?
He is. I'm saying I went there.
Okay.
I didn't pack all of my things and leave the house and I didn't tell them anything when I.
You. You don't want that, but you don't want that.
No, I don't want that.
Well, then you gotta fix this. We gotta be.
I've never had a problem with drugs. All the time I've been on probation, I've never had a negative drug test. I've never done any of
I
this.
know, but here's a big one.
And
This happened.
it's a choice. It's not my choice. I don't do.
But so you're under duress. I mean, somebody forced you into it? We're trying to help you.
I did ask her if she believed that he was going to take her life. She said no.
I don't think he's gonna
You are on a review. We haven't had a motion to revoke probation. We're trying to get all this fixed. And how are we doing from probation?
He's doing really good.
Is that right? You feel pretty good about it?
I do.
Good.
We had a little bump along the way. No drugs or anything. He just didn't go to a couple of appointments. I put him on the sanction to where he has to do a workbook with me. We went to Spinal Top together for his mental health, and he is completely involved in that. You know, he didn't know how to talk to the doctor, so we did it together to make sure that he got the mental health treatment he needed. He's doing community service as part of his sanction to make sure that he understands don't miss any more groups. But other than that, he stays sober. He is accountable for his actions.
Good. Very good.
He doesn't give me any trouble, so he's doing well.
Okay. All right. The victim in this case, how are you related to? Is that your child?
Yes, sir. It's my daughter.
Okay. What's the status on that?
He's not allowed to see her, and he's going to ask today if he could have visitation with her.
Do you want to ask me something?
Yes, sir. I was possibly see if I could maybe get like some supervised visits to see her. I think it would do well for him with his mental health and continue to motivate him to do the right thing.
Okay, let's do it then. But we got to do it in a structured fashion. How to, what plan?
We do.
Is there something you can put together in a plan, send to me, and I can just order it? And that everybody feels satisfied with?
You do
Is that good, sir?
Yeah, it works for me.
Good. Okay, yeah. We'll modify your probation order so that you can have contact with the child and in a way that the probation office feels like it's appropriate.
Is Children's Protective Services not involved? Are they third?
The baby lives with a family member, and I don't know. Do you have CPS?
Does CPS give you supervised visitation?
No, sir. No, sir. But I think the CPA
It's gone, yeah.
closed, yeah.
Okay.
That's closed out.
Yeah, I just don't know how that custody arrangement is, if
No,
there's sole custody with that.
And there's got to be some kind of monitoring at least at the beginning to make sure that it's a weaning process. You wean from disallowance to ultimately back into the old method, that the customary method of familial life, and we wean you into that, which has always been successful. We seldom have any problems with it, but it has, while you're on supervision, if something bad happened, then it would be who's to blame on that one. And yeah, I would have to say, well, I really didn't. I just sent him over there, and well, the same thing happened as before. That wasn't expected, but then who's to blame? It would be me. So we wean you into the process a little at a time until there's really very little monitoring and you're back into a conventional parenting environment.
Easing back into it, like easing back into it.
Yes, sir.
Yes, sir.
Yeah.
So he
I use
resides.
wean, easing into it is the right thing.
He resides with his grandmother, and she's really, really involved in his case.
You're talking about the defendant.
Yes, sir. His father has contact with the baby, and
The grandfather.
No, his father has contact with his daughter, and if we can, we're gonna see if the cousin has her, right? Her cousin. Yeah. If the cousin would allow the grandmother to supervise him with his daughter. He could never be alone with her, but as long as somebody is there with him, that's the relation.
Okay. Let's do that. And then we'll review in 6 months.
Okay.
We'll review it in 6 months to see how things are going, and maybe we can continue to expand the privileges. I've signed that. What else, sir? Anything else you want for Christmas? Family, everything.
I'm just working on, my goals and building up my life right now, so.
Good.
I appreciate it.
It's always, it's one step at a time for everybody,
One day at a time.
in the right direction.
Sometimes 1 minute at a time.
Yeah, good. So that's the way it is for all of us, really. We all have to, but what happens in our life is folks fall off the trail, lose direction. We try to help them. Sometimes we can't find them. They're lost. They stay lost, but we have enough of this, probation, 92% success rate. This probation office, 92.
It's up there.
Oh, that's really good. That's 1 out of 12, a failure. I wish we had 11 out of 12 successes. And so that's better than national average, I think, is 75%. So you can see what we do is positive, and it's obvious that we're appreciative of the needs of the probationers, and we celebrate success. And I think we hate failure, and we all feel like, we failed, and that's what we want. That's how dedicated this group is. So do your part, and it ought to all work out fine. Okay. Yes, sir. Just get a resetting for 6 months, and we'll see what goes on then. Thanks, Bryce. Eric Thames. Eric Thames, 13-16035. And this one's looks like all about money. Yeah. And back in February of 23, there was an arrearage of $14,000. $14,000, and here we are 2.5 years later. Where are we?
Currently, Your Honor, good morning, first of all.
Yes.
Currently, we are at $6,292.
That's really good.
Restitution.
Good. Wow. Okay. So, again, and we're not adding anything to this.
No,
we've stopped all the payments, the additional monthly amounts. It's frozen, right?
That's correct.
So we've got 6,000. How much?
$6,292.00 remaining.
And how much are you able to pay?
300 a month.
300 a month.
On the third of every month.
Looks like
that's 20
paid
months.
Roughly $2,700 since November of last year, Your Honor.
And he has been doing that consistently, Your Honor, since looks like
Now we're talking about 20 months, 21 months left at that rate, if not earlier, whenever you can. So we're looking at the finish line. It's
Yes,
there.
sir. I'm ready.
It's just not over the horizon. Now it's getting close. That's good. What else do you need from us to help you get to the end here quickly? Anything else?
No, sir.
If your probation officer is your lifeline, if you need something, and if you're about to make a choice that you're uncertain about, call and get direction. They'll help you. That's what they do. We're proud about the success rate we have, and you're one of them. So thanks, Eric. Why don't we look at it in 6 months?
Sounds good.
Okay. Thank you, sir. Good luck. Who else? Next, I have one file here on Joseph Ledet that I pulled aside.
Yes.
Okay, there.
It's Mr. Ledet.
Oh, yeah.
Right up here. Yeah.
What day is
Last time you weren't in a wheelchair.
No, I had a pressure wound came up on my leg, so I was using crutches, arm crutches.
Yeah.
I was treating it, that's why I'm.
Yeah.
Apologize.
Yeah, you need to, fix your help, but want to be in a wheelchair too long.
No.
It's necessary because then the other things, and
Way, a little bit.
yeah, things just don't, they're meant for ambulate, move around and stuff. And if you don't, some people are in age, you don't. Yeah, get you. Now, this one's a money thing and he was getting close. Where are we on it?
Since March, our last court appearance, he has made a payment of $122.
What's the balance?
In total, it's $5,482.88.
Okay, see, that's just a couple of $100 since 21. In December 21, there was $5,627 owed on this. And that really had only $200 has been paid since in almost 4 years. But you do what you can. What are you able, where are you able, where is it you're able to pay right now?
I'm just looking at the 150 a month, Your Honor, but then I had the for assistant, I've lost a BK on my left side, so that incurred a lot of.
Yes, sir.
But that's the plan going forward.
Okay. This is all restitution that's left, correct? That's what we're paying.
The balance for restitution is $4,687.88. He still has the fine and the court costs as well.
Which is how much?
The fine is $500 and the court cost is $295.
And again, how much can you pay a month? You say
150.
150. Is that going to be, you're going to be able to pull that? All right, we're going to order that.
Okay.
Pay at least that, which ends up being about $1,800 a year, which still gives us about 3 years. What? Some people have far longer to pay. And what else? Anything else on this one? Okay. Do you need anything else from us, sir, on getting your probation completed? And see, you're on deferred, which means at the end, you do well, complete that. It's dismissed. It's not revoked. You don't get a sentence. It's dismissed without a finding of guilt, which is what. Do you have a criminal history at all?
No.
You don't. Yeah, you don't want this. Yeah. Okay. Yeah, you want to be clear.
Okay.
All right, we'll see you back in 6 months. How we're doing. Thank you. Anything else? If not, that's it, huh? Have a nice weekend. And do we have trial Monday?
Sir.
Oh, boy. Allegedly.
Murder, sure.
All right. Have a nice weekend, everybody. Merry Christmas. Makes you feel a little cooler in the summer.
Tight schedule this morning, but we are moving forward. Sideways, backwards. Good morning, everyone. Good morning, Mr. Bland.
Hello, Judge.
I'm going to call your case. It'll take a minute. Clifton
Yeah,
Harder
that'd be great
versus
because I'm in another Zoom, so I'm sorry.
Casey, James, Clapp, and others. I have received a dismissal order signed by you. You and Mr. Bush have resolved this matter, and this case is dismissed, which I was hoping it would do after you guys were working on this. So I'll indicate brief record made. Matter
And
is
Judge, if I could
dismissed.
just tell you briefly, we did sell the house. There's been a closing, deed's been transferred. So it's all pretty done.
Very good. All right, thank you, Victor. Say hello to whatever judge you're in front of.
It's
And I'll
Judge
let you-
Namita Sharma. So
Well,
I
tell
will.
Judge Anita I said hello. She's a
I will.
friend of
Hey,
All right,
thanks,
thank you.
Judge. I appreciate you. Thank you.
All right, bye. All right, we have two damage hearings set simultaneously. Miss Wilson, your lawyer, Meg Bauer, is meeting with legal aid or with Mr. Boersma in the breakout room right now. So she's here and she's talking with the lawyer for the other side. So you stay right there. I have Daniel Penn versus Pete Edwards and Brittany Bauman. Mr. Penn, would you join us?
Yes, I'm here.
Could you turn your camera on?
I'm trying.
Miss Bauman, is Mr. Edwards with you?
He is currently downloading the app and I'm going to help him log in. He is trying to get it downloaded on his phone. But he's right here next to me on the couch.
All right, that's fine. That's good enough.
We can share a phone.
That'll work.
Yeah, I'm here. I'm just trying to figure out how to, if you can't see me, I'm not sure.
You did have it on earlier.
Yeah.
All right, the title of this case is Daniel Penn versus Pete Edwards and Brittany Bauman. We had a judgment that entered in March and the defendants vacated the property. We left open the issue of money damages and the plaintiff has filed a complaint for supplemental money damages. A lot, $12,807 is what he's asking for. And it's very vague. We've got rent, $5,200, electric, garbage, and then a great big fat other, which doesn't tell me anything, which is $4,800. So, Mr. Penn, I wish you could turn your camera on so I could see you.
Yeah, I'm trying to figure out how to do that. I see on the upper hand says Dan's iPhone, but I'm trying to wait a second. I think I see. Okay, I figured it out. Can you see me now?
Yes. All right.
Okay.
Ms. Bauman, if you could move where the window isn't behind you, I could see you better. That's much better. All right. Ms. Bauman, I'm guessing you don't agree that you own $12,552.
No, sir, I do not.
All right, this isn't a very good supplemental complaint. I can't really tell what's what. But let's start out with the rent. Now, one problem is they allocated 5 minutes for this hearing. I have another hearing that sets at 11:05. So there isn't enough time to do what we need to do here, but let's start. Mr. Penn, you contend that rent is $5,200. How did you come up with that figure?
Well, it was they ran my electric bill up to about $900, which I can absorb a couple hundred of that per month.
And, they was in arrears.
All right, well, let's stop for a minute. You're sitting in your truck. You don't have any paper in front of you. You're suing these people for $12,000 and you have the burden of proof. So how did you come up with this, the charge of $5,200 for rent?
Well, the thing of it, I have that, but it's on my phone and I can't access that at the same time I'm doing this. There was, bottom line is, there's $800 a month due for rent. And then there was utilities. And they froze my water pipes. And they burned up my stove. That
All
was
right,
$500 there.
just a minute. Would you both all please raise your right hand? You all swear or affirm any testimony in this matter will be true to the best of your knowledge and belief?
Yes.
Yes.
All right.
I do.
Ms. Bauman, how much do you believe the rent arrearage was?
I'm not sure, but I know we were paying all the way up to February, and we shouldn't have been because our furnace was not proper. It did not work. We did our best to stay warm. I don't know where he's coming up with all of the electric because we froze. We did not use electric heaters. I know there was an electric heater in the garage, and there was electric heaters to keep the chickens warm.
And I know the water was working just fine and dandy the day we left it.
Yeah, I mean, the only reason it wasn't working is because the water wasn't working is because he shut it off.
And the water pipes were leaking. I was the one doing the constant maintenance on any repairs to that apartment in the first place, along with all the numerous pounds of rodent feces we cleaned up for them too that had been accumulated for who knows how long, you know.
And we have all pictures and evidence of that. We sent it to a legal aid lawyer, and I'm not sure if they declined to show up today or if they had.
They're here. They're here. Let me wait a minute. And she's in a breakout room. Did you have a security deposit?
No, the first month we moved in was 2 years ago. 2 years ago, and I paid him the first month's rent, which was $800, which is all I could afford at the time, because that's all I made was $800. So I was paying him $800. That was my entire check.
All right, well, slow down. Now, Mr. Penn, you're the plaintiff, and you're woefully ill-prepared to pursue a $12,000 lawsuit. You don't have a pencil in your hand. You don't have a scrap of paper. You don't have any documents. You don't have the electric bill. You don't have the lease. You can't, this $4,800, I'm not sure where that came from. You just plucked it out of the air, or there's other issues. Now we just lost him. All right, there he's back. Miss Fowler, you indicate you've got stuff, including pictures and other things, which you wish me to consider.
Yes.
So, all right. So we aren't going to be able to do this. Neither one of you are prepared to proceed with a $12,000 lawsuit. But you do both agree that there's no security deposit.
Yeah.
I'm waiting for legal aid to come back in to see whether they are have any input on this.
Well, sir, can I
Mr.
make-
Penn, go ahead. Mr. Penn, go ahead.
Yes, yes, it is a little difficult doing this over Zoom. I have
Well, you can do it over
documents.
Zoom. You can just do a better job of it than zooming in from your truck while you're on the way from somewhere to somewhere else. You zoomed in all right, but, you're just not prepared to do this.
Well, it's, I have all kinds of proof and evidence and documents. If there was a way that I could send them to you or email them to you,
well, that's what a trial is. That was set for today. So I'm about ready to bounce the whole thing out of here. But what I'm gonna do is set it for a live hearing. And the parties are gonna have to come here to the courthouse. And I don't know when that is yet. But I'm waiting for a legal aid.
I think I could.
I know that what he considers evidence is just pictures of garbage around the place that had been left there by tenants before us, and is all, as far as anybody knows, is all pre-existing to whoever he had there before.
All right, well, we'll get into it. There's a lot. First thing we haven't even decided is how much is the rent? He's asking for $5,200 in rent, which you disagree with. The only thing we do agree on is there's no security deposit, but that's rent from when to when? I don't understand.
Sir, the last time that I received any money from them was $600, which was in November, but was applied toward the October payment that wasn't paid, and that's all I received ever since then. So $800, yeah, they still owe $200 at that point just for the rent, and and you know, they drug their heels, did not move until they was forcefully removed.
All right, well, that may all Stop. That may all be true, but you're the plaintiff. You can't just come in and throw some spaghetti on the wall, hope it will stick. You have to establish beyond a preponderance that what this stuff is. So we're gonna have to start with how much is rent? How much was it per month? When was it last paid? Which months are we talking about? November, December, February, March, April? Have to figure that number out. Then we're gonna have to see the electric bills and see if they total of $1,845. They allege that the furnace didn't work, so there should be abatement of rent. The rent should either be reduced or excused. There are other issues that you're asking for $4,800 of other, and I have no idea what that is. Ms. Bauman indicated they had spoken to you. This is Daniel Penn versus Pete Edwards and Brittany Bauman. They had some contact with legal aid. What can you tell me about that one?
I can tell you that Elaine was kind enough to send us the supplemental complaint. I think on Monday. I'm losing a little track of my days this week. And I had some serious concerns about it. I couldn't evaluate or advise Ms. Bauman without seeing that supplemental complaint, or so until I saw it, I should say. I had some serious concerns about it. I don't believe that this property was up to code in the first place or an authorized rental. So I'm not sure that the plaintiff's entitled to anything. But in light of preparing for Ms. Wilson this morning, and the fact that I didn't have the supplemental complaint in a reasonable amount of time, I told Ms. Bauman if I had time to speak with her, I would. Otherwise,
all right, well, I'm going to have to reset this. Mr. Penn's in his truck somewhere between one place and another place. He doesn't have any of the documentation. You raised an issue that had not been raised, whether this is even a legal rental. Now, the townships are Wild West. There's no zoning. And I don't think there was a lease. I don't think I ever had a copy of a lease. So there's a lot of uncertainty here, but neither party is prepared to go forward at this point, and I'm going to continue this matter for a live everybody comes into the courthouse damage hearing
Awesome.
at least 30 days out. We'll give legal aid an opportunity to meet with the clients and discuss it further. Mr. Penn, there are several issues. There's one issue regarding the habitability of the premises. There's another issue regarding what's called abatement of rent. They're claiming the furnace didn't work, so rent should either be reduced or excused. There are some other issues that they were going to raise. So this is more complicated than something. It was scheduled for 5 minutes. I'm not sure how that happened, but neither party's ready to proceed, and I don't know where to put this. So we're going to adjourn this. It'll be more than 30 days away, which will probably take us into late September, early October. But we'll revisit it. We'll have you come here with all your documents, your electric bills. I don't know what constitutes $4,800. You can't just put other $4,800 and expect me to grant it. So we will address that further, but I'm going to reset it. So I'll give you each a notice when I get the new date, and we'll provide that. Ms. Baumann, my advice to you is you continue to call legal aid and try to set up an appointment with them. But Ms. Bauer is about to be busy with me in another case. So Mr. Penn, we'll have a more formal hearing where everybody's here in the courtroom. You're good to All right, Ms. Baumann, you continue to call legal aid.
Yes, sir.
All right, thank you. Now, I think I've got Mr. Boersma stuck in the breakout room, so let's bring him back.
Judge, they were discussing a potential settlement, but I knew that Ms. Wilson was there in person, so I said, I'll let you guys have the breakout room or so you can talk without me being here. But if
Okay.
Ms. Wilson,
I let Ms. Wilson know that you were in the room with the lawyer. All right. I'm going to set this pen aside. So we'll just sit here and wait a bit.
If Ms. Wilson can mute the microphone in that room, I'd like to give her a phone call. Oh,
all right.
Signal issues. I don't know. We'll see if it'll work. Okay, looking good. And if I see them come back, we'll just hop back on, Judge.
It's a nice smile on his face.
Morning, Your Honor. You're muted.
You still making her call?
Yeah.
All right.
We're still waiting for them. So I think they were going to be calling. So. And we might be going back into a breakout session after this. So.
Okay, Judge, I'm back. Or we're off the phone.
There's someone in the judge.
Attorney Boersma, while we're waiting for Judge to get his audio back, I will tell you that I think that we have some very helpful information.
Okay. Judge, if you could put Ms. Wilson and all of us back into breakout rooms, then we can talk Salman. And you're muted, Judge.
All right, I'm gonna unmute it for a minute, but got the reverb on. You guys all join the breakout room and I'll stay here.
Okay, thank you.
Thanks, Judge.
Judge, I will need an invitation to the breakout room. Morning, Judge. You are still muted.
Also, Judge, the parties have stipulated that we would like to go off of YouTube.
Yeah.
For purposes of entering a settlement.
There we go. All right, you can hear me now, but it reverbs. We were not muted at any time earlier. All right, I'm gonna close out the live feed. Miss Wilson, why don't you come right in the courtroom?
Okay.
All right, that finishes our portion of the day. We got
The City of Taylor versus Michael Oliverio. Sir, can you tell me your first and last name?
Michael Oliverio.
Afternoon, Your Honor, Jeffrey Santo on behalf of Mr. Oliverio, waive formal readings and do.
All right, sir, did you go over your constitutional rights with your attorney that are outlined on this advice of rights form? Sir, did you go over your constitutional rights with your attorney? Are you saying something? Can you say yes?
There's a green light on, right? Like,
Oh, I don't know if the audio's not turned on the device. There we go. Sir, did you go over your rights with your lawyer?
Your Honor, yes, I did.
Did you understand your rights?
Yes, I did.
And did you give your attorney permission to sign your name on that form?
Yes, I did.
All right, I've entered a not guilty plea on your behalf for purposes of arraignment. I've signed a request for a court-appointed attorney, Mr. Fanto, as to bond.
I appreciate his history. He's got some holes. The court did see him yesterday on a traffic warrant. He has a court date on August 20th. Gave him a personal bond on that. He was a passenger in a motor vehicle that was stopped for a civil infraction. There were some controlled substances found in the vehicle, and that seems to be the subject of the charges against Mr. Oliverio. I would request a personal bond this time, Judge. He is on Social Security, lives with his mother.
Is there a way we can have it all on the 20th, the same day? What's going on here?
That's what we're going to try.
All right. So he has multiple bench warrants out. 3 out of Romulus, 3 out of Allen Park, Lincoln Park, Dearborn Heights. He has a history of criminal history that goes back to 1995. He has multiple assaultive convictions on his record. And so he's a flight risk and potentially a danger to the community. I'm not giving him a personal bond. He has a $5,000, 10% bond. Sir, you're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You cannot possess or have access to firearms or other dangerous drugs. You cannot consume alcohol or illegal drugs. You may be subject to testing at your expense on demand. And those are the terms of your bond, sir. And we will set this for a pretrial. All the other cases are up on August 20th.
That's what it appears to be, Judge, yes.
Connor, I have $100 in my property. Is there a way I can get a smaller bond so I can bond out? I have exactly $100 in my property. I'll forfeit the $100 right now if I can do it.
No, you have another bond on another case, and you're not going anywhere anyway. Sir, you have 4 different cities that want to see you.
You need 500 total. If you'd mark the file medical, Judge.
I will. All right, we're all set.
Thank you.
So I have these. Yeah.
Been told for traffic.
What's that?
Speak down in the speaker, sir.
Can you hear it?
Yep.
All right, this is 243310, 243311, and 252327, the People versus Peter McFadden.
Afternoon, Your Honor, Jeffrey Dent on behalf of Mr. McFadden. Waive phone reading, standing, request warrant be recalled.
Okay. Sir, did you go over your constitutional rights with your attorney that are outlined on this advice of rights form?
Yes.
Did you understand your rights?
Yes.
And did you give your attorney permission to sign your name on that form, sir?
Yes.
Okay, I've entered a not guilty plea on your behalf on these three matters. From Walmart.
There's nothing prior to the allegations from December. He indicated that he didn't get notice for that court appearance. I did advise him, he doesn't know what his date is, by the end of next week, contact the court. But no other reason to believe that he would not appear, Judge. I think he's appropriate for personal. Again, the traffic or his holds are traffic related.
Yeah, I see. I mean, he has 3 cases up here. But I see no prior criminal history on his record that would make him ineligible. All of the holds are traffic, sir. So on each file, I'm giving you $1,000 personal bond on each file. These are your bond conditions. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately be notified or immediately notify the court of change of address or phone number. You're not to return to Walmart while this case is pending. You also cannot have any contact with Alan, Franklin Rogers. I don't know if you know him, sir. That's the individual that was the alleged victim on the larceny from an auto. You're not to have any contact with him. You're not to go to where he lives, works, or goes to school. Do you understand me?
Yes, ma'am.
Okay, you cannot consume alcohol or illegal drugs. You may be subject to testing on demand at your expense. And we will set you a court date on these as soon as possible.
Thank you, Judge.
I got a question. Is I'm getting released or no?
I mean, you're from our holds. I don't know what the other courts are doing. You do have these traffic warrants, sir. So I don't know. You've got one out of E-Course, Wesleyan, and Dearborn Heights. I can't tell you what they're going to do. But on our cases, you have $1,000 personal bond on each case. And I have also, just for the record, signed the request for a court-appointed attorney.
Thank you.
And we're all set. Thank you.
Thank you, Your Honor.
Thank you.
On behalf of Mr. Hop, Mr. Hop, state your name for the record, please.
You Hop.
Your Honor, can you briefly approach?
Yes, Your Honor.
Your Honor, today's date and time set for final settlement conference. At this time, I'm going to be asking for an adjournment. New updates to this case have come out, and at this point, the defendant is in custody for failing to appear at a PTO violation here up in circuit court. There's also a new case that will be upcoming and will be charged today for an FA that occurred on July 26th. So in this case, I'd be asking for an adjournment to the October dates, as well as the defendant's bond being denied in this case for the bond violation that is upcoming. for the FA.
Your Honor, no objection to the adjournment to the October final settlement conference date. Regarding bond, I'd ask that the court keep his bond as it is. As the court knows, this case hasn't been charged out yet. He hasn't been arraigned on it. If he's going to be held on that case, a magistrate will make that decision when he is arraigned.
What I will do is I will adjourn the jury final settlement conference and jury selection to October 17th, 2025, 9 a.m. for the settlement conference, and jury selection, if necessary, October 20th, 2025 at 8:30. Given the circumstances, what I will do at this point is I will revoke the defendant's bond. And that's based upon the representations pending a hearing on the violation. If you'd like me to set that, then you just let the court know. We will set a violation here. Okay. All right. So ideally, the best thing is to set it after the arraignment. Sure. Man, all right. They bring me. They're ready for the next one. Okay, court does call the case of the people versus de jure Bond Sanders.
Ellie Zed on behalf of the people, Your Honor.
They weren't ready.
How's it going, Judge?
I want Bird and Matt to wait. Bond Sanders. I'm just letting you know how I feel.
Good morning, Public Defender Lauren Perny on behalf of Mr. Bond Sanders. State your name for the record, please.
Deja Bond Sanders.
Your Honor, we have come to a resolution. Mr. Bond Sanders is going to plead as charged in this case. This was part of a global resolution that included some felony charges that were up 2 weeks ago at exam. Those felony charges were dismissed and he pled it on a DB there.
And that's correct, Your Honor. That file is coming before Your Honor. I believe that sentencing was adjourned. After the plea in this case, though, Your Honor, the victim is here to request contact. I'm not sure if the court gives on other file, it's still no contact as well. I'm not sure if the court has that file.
I do not have that file with me. Sorry.
Yeah, scheduled for the 18th. Did you say that? Sorry. The sentencing on the first DV is scheduled for the 18th. I assume Ms. Pilara is going to.
I'm going to let her take a look at all of that before I make a ruling on contact on this, just to let you know. I'm going to see my phone. All right.
Your Honor, sorry, before we enter the plea, Mr. Bond Sanders is asking if you'd consider entering or giving him back his phone privileges. They were revoked. I couldn't give you a date, but several weeks ago, given the representations made by the people.
That's right, Your Honor. He was contacting the victim from custody. That's why they were revoked.
Correct. And which was a violation of his bond. I am not inclined to reinstate those phone privileges at this point. Given that everything is coming up, I will take a look at everything come the 18th. Fine. But may I have him sworn?
Raise your right hand. Do you solemnly swear or affirm testimony you're about to give be the truth, the whole truth, and nothing but the truth, so you got it? Lower and then say your name again.
Deja Bond Sanders. Sir, it is this court's understanding that you're going to plead guilty to the charge of domestic violence. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that? Yes. Still wish to plead guilty? Yes. And to that charge, how do you plead? Guilty. Now, you understand that by pleading guilty, you'll not have a trial of any kind? Yes. All right. You signed an advice of rights form, is that correct? Yes. Any question regarding any of those rights? No. Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form. Yes. You understand you're giving up your right to appeal of right? Yes. Are you on probation or parole? No. Has anybody promised you anything other than what's been stated here today on the record to get you to plead? No. Anybody threaten you or coerce you? No. You're doing this voluntarily? Yes. And of your own free will? Yes. And because you believe that you are indeed guilty of this offense? Yes. On the date of June 27, 2025, at the location of 2265 Glencoe Hills Drive, Apartment 5, Pittsfield Township, Washtenaw County, State of Michigan, what did you do regarding, is it Natalisha Henderson that makes you think that you're guilty?
I threw sand at her.
Pardon?
I threw sand. I threw sand at her.
You threw sand at her, so you threw something at her?
Yes.
Okay, and who is she to you?
That's the mother of my son.
Okay, so you have a child in common?
Yes.
All right. And you didn't have her permission to do that, did you?
Uh,
All right. And you did it intentionally?
yes.
All right. If I accept your plea and you commit misconduct between now and the time of sentencing as defined by the Michigan court rules, any sentence agreement or evaluation, the court is no longer bound by, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes.
All right. Counsel, are you aware of any other promises, threats, or inducements which have caused this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule?
Yes, Your Honor.
Yes.
All right. Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation, pre-sentence investigation, and report. He is set for sentencing on that other case on the 18th?
Yes.
Is it?
That's correct.
We can do the 18th.
Yeah.
Pardon? Yeah. Sentencing in this matter will be August 18th, 2025 at 1 p.m. Bond with its conditions will continue.
Thank you, Your Honor.
Right, thank you. Court does call the case of the people versus Ali Hayeri.
Here.
Ally Zend on behalf of the people, Your Honor.
Your Honor, good morning, Joe Simon on behalf of the defendant. State your name, Ali Hayeri. Yes, Your Honor.
Your Honor, today is the date and time set for final settlement conference. At this time, the people are unable to proceed.
Accordingly move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without prejudice.
Your Honor, request that the court check the box returning prints and arrest data.
I don't have the. I don't have a dismissal.
Okay, I can prepare one for the court.
That's fine.
Thank you.
Court calls the case people versus Robin Muhammad.
I'm sorry.
Oh, they just called for it.
Ally Zend on behalf of the people, Your Honor.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Muhammad.
He's coming out. I may have called it a bit early. Weidling, why was he up there trying to talk to you?
Oh, Mr. Simon?
No,
He always talks.
no, this one.
I'll talk to yeah.
Don't talk to him. You can talk to Joe. Talk to him. Ramin Mohammed. He just came up there. He looked like he was up to something.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Muhammad. State your name for the record, please, sir.
Rahman Mohammed. Thank you.
Your Honor, today is the date and time set for final settlement conference. At this time, the people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice. Thank you.
Thank you.
Thank you.
Court calls the case people versus Kiera Peterson.
Ally Zend on behalf of the people, Your Honor.
Good morning, Your Honor. Tina Sachs on behalf of Ms. Peterson's and son.
What?
And son.
And son?
Unfortunately, she wasn't able to secure
was what?
childcare. She wasn't able to secure childcare. We know this is a dismissal.
Want me to punish her for bringing baby?
Absolutely not. He's
Oh,
drunk.
all right. I didn't know what you want. How old?
10 months.
10 months? Oh. See, now I can be in a good mood.
That's what I said.
Huh?
I said the same thing.
I know, I'm a sucker for babies. But don't everybody be bringing you,
I was like, I'm always having a baby on my hip for now on.
because some of them don't know how to behave. This is much like my staff. All right.
Your Honor, today's concept for final settlement conference. At this time, people are unable to proceed.
Your Honor, defense must for dismissal.
People being unable to proceed, this case is dismissed. That is without.
Thank you, sir.
Thank you. Court does call the case, People versus Elizabeth Raggett.
Conrad Silver on behalf of Dismissal Township.
Good morning, Your Honor. Sam Bernstein with on behalf of Ms. Raggett. Ms. Raggett, can you please say your name to the court?
Elizabeth Raggett.
She's going to enter a plea
Yes, Your Honor.
to OWI. Is that correct?
Yes, Your Honor.
That's correct.
May I have her sworn?
You solemnly swear or affirm testimony you're about to give the truth, whole truth, and nothing but the truth, help you God.
I do.
Lower your hand and say your name again.
Elizabeth Raggett.
All right. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Court could order community service or any rehabilitative services the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
I do, Your Honor.
Do you still wish to plead guilty?
I do, Your Honor.
And to that charge, how do you plead?
I plead guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
I do, Your Honor.
All right. You signed an advice of rights form, is that correct?
I did.
Any question regarding any of those rights?
No.
All right. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do.
You understand you're giving up your right to appeal of right.
Yes, I do.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today
No, Your Honor.
to get you to plead to this?
Right.
Sorry.
I understand.
Has anybody threatened you or coerced you?
No,
You're doing this voluntarily?
I am.
Of your own free will?
Yes,
And because you believe that you are indeed guilty of this offense?
I am, Your Honor.
On the date of March 27, 2025, at the location of Carpenter Road, Pretrial Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
I did.
What did you have and how much?
I had about almost 2 bottles of wine.
All right. Were you stopped by the police or was there an accident?
There was an accident.
What happened?
I pulled out, and I misjudged, and I went directly into another vehicle. It was trying to turn left. I'm really sorry.
Did the police arrive?
They did.
Were you taken to the hospital?
I was.
And was there a blood test?
There was.
And the blood test was 0.191?
Yes.
All right. Do you have any reason to dispute those blood tests?
No.
Ma'am, you understand that if I accept your plea, if between the time of my acceptance of your plea and the time of sentencing, you commit misconduct as defined by the Michigan court rules, that you would not be entitled to withdraw your plea and any sentence evaluation or recommendation, the court would not be bound.
I understand, Your Honor.
Counsel, have there been any other promises, threats, or inducements that you're aware of that have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
August 27th at 12.
August 27, 2025, noon. All right.
Could I just bond, Your Honor?
Yes, you may.
Ms. Raggett has, she's been in jail for 3 weeks now. Obviously, tell by her demeanor that candidly she has struggled with alcohol. That's something that she's very well aware of. She knows that she needs help. She had signed up for the Trinity Addiction Services program prior to her incarceration. It was a 3-day-a-week program that would involve counseling and group sessions, and she thinks would be really beneficial for her. We talked about the the plea form, and specifically if she were to be given the privilege of release, any sort of drinking behavior would likely result in jail incarceration rather than probation. So she's pretty well aware of that, Your Honor. She has pressing family concerns that she's hoping to get back to in the world, an ill father, and a son as well. So she has some responsibilities she's very, very eager to, and I can tell she's actually quite ashamed at her behavior, and she's hoping to get help, Your Honor. So she's asking for the chance to be released and prove to the court that she can get herself to that program and follow through on that.
Was she originally on a PR bond?
Yeah, she had bond violations, Your Honor.
Yeah, that's what I thought. But she was on a sober list.
Yes.
All right. And then had the violations. All right. Anything from the people regarding this?
Your Honor, if the court is considering releasing her, the people would request a scram.
When would you get yourself enrolled in the program?
I am enrolled.
You are enrolled?
Yeah, I had an appointment on the 28th and I couldn't attend because I was here, but they're just waiting for me to get out so I can get back.
And that's the Trinity addiction?
Trinity Health is 3 days a week. Yes, and it also includes testing, Your Honor.
What I'm going to do is I'm going to give you a shot.
Thank you.
It's going to be up to you though.
Okay.
So I'm going to reduce her bond to a personal cognizance of $25,000 bond.
Thank you.
Defendant is to be placed on a scram tether unit prior to her release.
Thank you, Your Honor.
Right? Thank you. I'll see you at second.
Thank you.
Right? And Mr. Bernstein is right. That if you violate, it's going to be a jail sentence.
I understand.
Thank you. Court does call the case, People versus Brittany Williams.
Alexander, on behalf of the people.
Yes, Your Honor, please, this honorable court.
I told you don't call it. I told you not to talk to him, but I said I didn't want his case called either.
Oh, I missed that part.
No, him and Mac, they're supposed to wait here all day. No, it was him and Mac.
Oh.
That was.
No, first time.
No, Sam could go. Yeah, Sam's fine.
All right, thank you. Brandon Bird on behalf of Brittany Williams. Ms. Williams, can you please take your full name?
Brittany Marie Williams.
Thank you.
Your Honor, today's date time set for final settlement conference. At this time, you are unable to proceed.
Respectfully request dismissal, Your Honor.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
All right, thank
You
you.
and the honorable court have a great one.
You do the same. That's it for you?
That's it for me today.
Really?
Yeah, really.
It's always a pleasure seeing you every day.
Vice versa.
No, I mean that from the bottom of my little heart. All right, take care. Court does call the cases of the People versus James Dragon.
Alexander, on behalf of the people, Your Honor.
Conrad Siller on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Raggett. Mr. Raggett, please state your name for the record.
James Patrick Raggett III.
Thank you.
And Your Honor, today's date time set for final settlement conference on our file, and at this time, people are unable to proceed.
In both cases?
Just the 920.
923. Okay, go ahead.
Move to dismiss, Your Honor.
People being unable to proceed. Case ending in 0923. That case is dismissed. That's without.
On the other file, Your Honor, that is the high BAC case.
Yes.
Your Honor was willing to have the file today, given the potential of a dismissal today. He's being held on bond denied because of the domestic violence case that was picked up. Given that the case has been dismissed, I would ask that the court consider reinstating his personal bond. He has been on a scram tether since January of this year. He's had no alcohol or drinking or tampering violations on that tether. He was just picked up on again, the domestic violence case. If the court is willing to release him today, he is asking the court to consider giving him a sober link. He, as I said, he did have no violations on the scram. He's been on it, well, been in custody for a few weeks now, but before that, no violations on the scram. He works with bikes, like literal pedal bikes. He runs both the
As opposed to what other kind?
sometimes I think electric bikes. Yeah, there you go.
Motorcycles. Sometimes
Yeah.
people think motorcycles.
So he works at a place that sells bikes, and he also runs a nonprofit for children. So teaches young people how to ride bikes. So he's asking a sober link just because the scram can get in the way of pedaling.
Can get in the way of pedaling?
So I have more information if the court wants. So because he has tattoos on his legs, the device that detects.
No, you keep going because I don't know who's buying it, but go ahead.
The device that detects or tracks the skin has to be on clean skin, I guess, for lack of a better phrase. No, non-tattooed skin. And the only place that can be is the inside of his ankle.
Oh. Okay.
The people will request the script. He's done very well on it, and I want him to continue to do so.
They no longer have it on you, sir? No. It's not. All right. We are set for September 17th on this case.
Yes, Mr. Raggett is going to get a assessment done. I think we set it out that far. So if he were to be released, then he can get that done, get it to the people for consideration of a reduction.
All right. What I will do is I will reinstate his previous bond. However, he has to be on a scram tether prior to release. I understand that he's done very well while on the scram. But I do recognize also that his blood alcohol was a 0.31. So a scram tether is justified in this case. All right. All right.
Thank you, Your Honor.
Thank you. You're gonna need this. Court does call the case of the people versus Keith Davis.
Ally's the one you have. People, Your Honor.
What?
Okay.
You know, I told you, leave that. They never listen. They never listen.
Judge, for the record, I'm listed on the multiple names, so it's not their fault.
I see.
It's not their fault. Good morning, Judge Simpson. Hugo Mack appearing with Mr. Davis. And just a record, I want to know my client's wearing long pants today. And
yes.
In recognition, the National Weather Service did cancel a flood warning. So
Okay.
We're in good shape here.
In good shape. Your name, sir? Keith Davis. All right.
Your Honor, today's the date time's up for final settlement conference. At this time, people are unable to proceed.
Your Honor, make a motion to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you so much, Judge.
All right, thank you.
Have a great day.
Thank you. Take care. The court does call the case, people versus Paris Calloway.
Conrad Silver on behalf of the township.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Calloway. Mr. Calloway, please state your name for the record.
Good morning, Paris Calloway.
Thank you.
Your Honor, this is the date time set for final settlement conference. People are unable to proceed. I did have a plea offer with Mr. Calloway as well, from the record that he's rejecting that plea offer.
All right.
Is that correct, Mr. Calloway?
Yes.
All right.
Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without.
Thank you, Your Honor.
Thank you. Court calls case people versus Maurice Cahey.
Conrad Siller on behalf of Eastfield Township.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Cahey. Mr. Cahey, please state your name for the record.
Maurice Cahey.
Thank you.
This is date and time set for final settlement conference. People unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
All right, thank you. Court calls case of the people versus Thomas Bennett.
Ally's on behalf of the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Bennett. Mr. Bennett, please state your name for the record.
Thomas Bennett.
Thank you.
Your Honor, today's the date and time set for final settlement conference. At this time, the people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you.
Court calls the case people versus Nicholas Bonsanek.
Ally's on behalf of the people, Your Honor.
And Assistant Public Defender Natalie Pate on behalf of Mr. Bosnack, who should be present via Zoom.
Why is she?
He's in there. See?
Yes.
Oh, it's my Kiwi. Yeah.
Oh, sorry, Assistant Public Defender Natalie Pate now with and on behalf of Mr. Bosnack. Mr. Bosnack, do you mind turning on your microphone and stating your name for the court if you can hear us?
Full name Nicholas Michael Bosonic III.
All right, thank you, sir.
Your Honor,
Thank
today's date and time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice. All right, sir, thank you very much. Take care of yourself.
Thank you, Your Honor. Thank
And
you.
all those down in Kiwi land, eh?
Thank you very much.
Take care.
Thank you, sir.
You have a good day.
You too.
Bye-bye.
Court calls the case, people versus Jason Brooks.
Ally's on behalf of the people, Your Honor.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Brooks. State your name for the record, please, sir.
Jason Brooks.
And Your Honor, today's date and time set for final settlement conference. At this time, people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice. Thank you, sir.
Thank you.
Court calls the case of the people versus Shimona Byers. Yeah,
Ally's on behalf of the people, Your Honor.
I think it's Jay Jamoya. I give up.
Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Byers. State your name for the record, please.
Deja Moye, Byers.
Deja Moye.
Your Honor, today's the date and time set for final settlement conference. At this time, people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you.
Court does call the case, people versus Ashton Ebler.
Ally's on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Ebler, who is approaching. Please state your name for the record, sir.
Ashton Ebler.
All right.
Your Honor, today's date and time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you. Court calls the case of the people versus Marquand Gracie.
Ally's on behalf of the people, Your Honor.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Gracie. Mr. Gracie, please state your name for the record.
Marquand Q. Gracie.
Thank you.
Your Honor, at this time, the people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice. Thank you, sir.
Thank you.
Court calls the case, people versus, is it Hishar Isa?
Ally's on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr.
Good morning, Your
Issa,
Honor.
who stands to my right.
Good morning, sir. State your name.
Shah Issa.
Your Honor, today's date time set for final settlement conference. At this time, people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you, sir.
Thank you, Your Honor.
Court calls the case of People versus Douglas Lee.
And Lisa, on behalf of the people.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Lee, who stands to my right. Please state your name for the record, sir.
Douglas Lee.
Thank you.
Your Honor, today's date time set for final settlement conference. At this time, people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you, sir.
Thank you, Your Honor.
Court calls the case People versus Jaquil Lloyd.
Ally Zen on behalf of the people, Your Honor.
Good morning, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Lloyd, who stands to my right. Please state your name for the record, sir.
Jaquil Lloyd.
All right. Put your hands up. I'm sorry.
Your Honor, today's date time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you,
sir. Thank you.
You said that.
Why'd you shake her hand? She didn't do anything. No, I'm kidding. Court calls the case People versus Adriana Taylor Hamby.
Ally Zen on behalf of the people, Your Honor.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Taylor Hamby. Say your name for the record.
Adriana Taylor Hamby.
Thank you.
Your Honor, today's the date and time set for final settlement conference. At this time, people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice. Thank you. Thank you, Sandy. Take care.
Thank you.
Bye. She on her way. Bye. Running. Court does call the case People versus Ronald Altman.
Ally Zen on behalf of the people, Your Honor.
And see counsel back there. Okay.
Morning, Your Honor. Don Smith on behalf of Mr. Altman.
Your name, sir? All right.
Your Honor, today's date and time set for final settlement conference. At this time, people are unable to proceed.
Your Honor, we ask that the matter be dismissed.
People being unable to proceed, this case is dismissed. That is without prejudice. Thank you.
Thank you, Your Honor.
Take care. Court calls the case of the People versus Issa Awad.
Ally Zen on behalf of the people, Your Honor.
Good morning, Your Honor.
Jeffrey Bledsoe Ford, Jeffrey Gerald Bledsoe Ford on behalf of Issa Awad.
Okay.
Your Honor. Oh. My
Your Honor,
client
today's-
is here today. I don't know if oh, go on.
Your Honor, today is the date and time set for final settlement conference. At this time, I would be asking for an adjournment of the final settlement conference. We were attempting to reach out to the victims and found out the number that we had was just for the business that they worked at. And when we were finally able to make contact, we found out that both of our victim and witness are either out of town today or getting medical treatment for something. So we would ask for an adjournment so we would have a chance to speak with them and discuss this case.
Response?
No objection.
All right. State your name, sir. 'cause you didn't. All right, thank you. What I'm going to do, sir, is I'm going to adjourn your case. I'll adjourn the jury final settlement conference. We'll set a new one for October 17th, 2025 at 9. And then jury selection in this case, October 20th, 2025 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
All right, thank you.
Thank you.
Thank you.
Bye.
Good day.
Bye.
Thank you.
No.
Okay, so I don't know.
All right, no, that's fine, sir. Oh, you printed it for,
For Miss Engine.
Got it. He's here.
And that's him right there.
Okay, so they're waiting. All right. Court stands in recess. I'll stay seated. Paul, is it Gutzlaw?
Your Honor, Jillian Aiken for plaintiff.
Your name, sir?
Paul Gutzlaw.
Nice to hear. All right, where are we on this case?
Your Honor, the parties have reached a conditional order of dismissal. And so we can place the terms on the record.
Yes.
All right, thank you, Your Honor. This is a case for termination of tenancy, and this matter is going to be dismissed without prejudice, subject to the terms of the order. Defendant Paul Gutzlaw shall vacate the leased premises. I'm not going to put the address on the record, and shall turn in keys on or before September 15th, 2025. As of August 8th, 2025, defendant's balance with plaintiff is $3,022.13, which includes court costs of $172. Defendant shall pay the arrearage of $3,022.13 as follows: $1,069 on or before August 8th, 2025, and defendant shall pay the remaining arrearage plus the final utility bill and prorated September rent in monthly installments of $500 commencing October 15th, 2025, and continuing each month thereafter until the arrearage is paid in full. It's not in the order, but if Mr. Gutzlaw misses a payment, his account is going to be sent to collections. That will resolve that. And defendant shall comply with the terms of the lease. Plaintiff shall provide a neutral landlord reference if contacted about defendant by a prospective landlord. And then in the event the defendant fails to comply with the terms of this order, plaintiff will be entitled to an immediate judgment for possession with a writ of restitution and an order of eviction to issue immediately upon the filing of an affidavit of noncompliance with the court without hearing but with notice to defendant via mail. On the copy that I submitted to the court, it included a provision 8, and Mr. Gutzlaw is requesting that be stricken from the order. I can delete it. Okay.
Go ahead.
I can delete it and then resubmit it.
Okay.
So that it does not include that. I've provided.
What is the provision 8?
It says defendant specifically waives the 14-day notice and objection period set forth in MCR 2.602C2D. I think Mr. Gutzlaw is concerned about waiving rights that he doesn't necessarily hasn't looked into what he would be waiving.
What he waived. All right. All right.
And then we did go over MCR 4.201J, but I'm hoping that can be placed on the record as well.
All right, sir, is all of that correct?
I believe so, yes, sir.
All right. Is there, just look at this. Do you have any questions or concerns regarding any of the provisions other than paragraph 8? And I'll get to that in a moment, but
I don't.
No?
No.
All right. Okay, and sir, why don't you lay out for me what's your issue with paragraph 8?
Well, it appears that I'm giving up a 14-day notice, right? That I don't understand, and that wasn't really part of the discussion when we came to this agreement.
Okay, and that's probably because most of the time that these are coming through, that's waived. So let me, so that you understand what that I'll give you what the legal effect is and what the practical effect is. Okay. All right. So normally what would happen if there's a violation in some respect, you would be entitled, they'd have to send you notice. You get 14 days notice regarding that before anything could happen. Okay. While that's there, the practical effect of how things work is that, let's say, just hypothetically, there's a lease violation, say the 31st, before the move out date. Say September 1st. Okay, just picking a date. And they file for their judgment and order of eviction. You still have a mechanism by which you could get before the court. That's the practical effect. You just don't have that 14-day period. So if you believe they're wrong, you can file a motion with the court to be heard, and you'd be heard. That's the practical effect of how this operates. Okay. So while I understand the waiver of the 14 days, not so much. Here's part of the problem and why it's also included. Okay. Because in particular on the cases such as these, where there is the move out date. All right. Technically come September 15th, because I think you're supposed to vacate by the September 6th. Well, technically by September 16th, the plaintiff theoretically, in order to get possession of the premises, would have to wait another 14 days. But what they've done is they've already given you the time to move. All right. So that's probably the best that I can explain it as to what it is and why the plaintiff would want it. Why from the tenant side, yeah, it's waiving that 14 days, but really it's not like you wouldn't be able to get before the court to have whatever issue you had heard. So
this landlord has been very unfair about claiming violations. Very minor things that could be handled by a reminder. He has levied his own fines and fees.
Gotcha.
With a rapidly escalating.
Why don't I do this? What if I did this to paragraph 8? Maybe it solves both problems. Okay. What if I just said you're waiving the 14-day notice and objection period only as to the September 15th move out date?
Fine.
So that if it's anything else, you get the 14 days. How's that sound?
I'm very good with that. Thank you.
Okay.
Your Honor.
That's satisfactory to us as well.
I've added that to that. I need to hand this to you guys because I'm going to need signatures for all of that. And sir, when they give that to you, you have 3 business days from the time that I sign it to think about this. If you believe that there's some right you have in a cert, some confusion on your part, or some other type of misunderstanding, you'd have those 3 business days to think about it, file a motion with the court in that time frame. Doesn't mean I grant it, but you have that time frame to do that. Okay?
Thank you.
Get my pen to work. I'm going to sign off on the conditional order dismissal. Thank you guys for working it out.
Thank you.
Good afternoon. Are you Yvonne Jane Briggs?
I am.
This is Judge Middleton. I saw that you'd been arrested, I think this morning. And
Yes.
so I stuck around to do this jail arraignment, and Mr. Keith Stickley from the Public Defender's Office is also with us. Ms. Briggs, let me tell you what you're charged with. The allegation here is you're not in my system. Give me a minute. That on March 1st, that you possessed methamphetamine, maintained a drug house, and had possession of a firearm as a felon. Let me get this. I had it up in my office. All right. The sequence of this is a little interesting. This file number is 251218. The warrant alleges that on March 1st at your home in Mendon, you did possess methamphetamine, 2 counts, maintained that house as a drug house. First 2 counts are felonies punishable by up to 10 years imprisonment. The second count, or the third count, maintaining a drug house, is a high court misdemeanor punishable by up to 2 years imprisonment and a fine of up to $25,000. Count 4 is a charge of felony firearm. They allege that you possessed a pistol while you possessed these controlled substances. Now, as Ms. Briggs, as I indicated, this alleged to have occurred on March 1st. They stopped you in your car, then they searched your residence, found some stuff in your purse allegedly, and also found some stuff in your house. That was March 1st. They sent the stuff to the crime lab, and it took a while for it to come back. And the warrant was issued on June 17th, signed by the prosecutor on June 11th. So this was alleged to have occurred on March 1st. They also have charged you with having an abandoned vehicle, this same vehicle, this Ford Edge. And that case is in limbo. I don't know what the status of it is. You got a ticket on April 3rd that you had a 2002 Ford Focus on your property with no plate. So that's April 3rd, and I don't know what the status of that is. The person that was with you in the course of this case was I looked at this during the lunch hour. Was Richard Joseph Leonard. He was the passenger in your car and also resided at your house. And there was some indication that some of this may have belonged to Mr. Leonard. This was March 1st. So I looked up to see what happened to Richard Leonard. Richard Joseph Leonard. There's more than one Richard Leonard. And lo and behold, on April 11th, at the same place, he's charged with assaulting you with assault, 2 counts of assault by strangulation, possession of a dangerous weapon, domestic violence as habitual offender, 3rd offense. That same day, April 11th, Mr. Leonard is also charged with possessing methamphetamine and fleeing, eluding a police officer, and driving with a suspended license. That case was bound over to circuit court. Both of those were. And Mr. Leonard is being dealt with separately. He did not get charged with anything that allegedly occurred on March 1st, and you didn't get charged with anything that allegedly occurred on April 11th. Nonetheless, you are charged with this. It has a felony firearm charge. You were previously charged with a methamphetamine case last year, I think. (2023) in file number 23 2346, you were charged with possession of methamphetamine at the same address, 315 East Street. They found needles and syringes and other things. They offered you a plea to reduce to a use of methamphetamine, which you declined. And the matter was set for prelim, and then the prosecutor dismissed it on January 16th of 24 for what they called prosecutorial merit. So the previous charge of methamphetamine was dismissed in 2024. The person that was with you on this case has been bound over to circuit court on assaulting you. And the firearm that was in the house on March 1st has been attributed to you and charged as a felony firearm. That is the crime that carries a mandatory minimum 2-year prison sentence preceding and consecutive to any other charge. So this happened in March. The police report was turned in May. The prosecutor authorized it in June, and they arrested you apparently this morning. When were you arrested?
This morning.
How did they arrest you?
An officer came to my house.
So the warrant was authorized a month and a half ago, and apparently they're serving some warrants and you got arrested. All right. So what were you doing when they came to your house?
This morning?
Yeah.
I was sleeping.
All right. Where is Mr. Leonard?
He's on premises somewhere that in jail. He's still in jail.
Is he? He's not living with you.
No. I talked to the victim's advocate, thank you. And they said that he was still over here.
Let's take a look. All right, who else lives at your house?
Nobody.
Yeah, he's been in jail 119 days. All right, well, let's talk about what to do with you. First thing I'm going to do is I'm going to appoint an attorney for you.
Thank you.
It will be Rhonda Ives, I believe. That's up to the Michigan Indigent Defense Team.
That is true, yeah.
The pre-exam set for 8/19 at 8:30. And a prelim, if needed, set for 8/26/25 at 1. All right, you still live at 315 East Street, is that correct?
Yes.
There was a methamphetamine involvement in 2023 that was dismissed in 2024. There was this incident in March, and there was another incident in April, which leads me to believe that methamphetamine is a factor here. Are you employed?
No, I'm not.
Do you have any source of income?
Oh, before Mr. Leonard got locked up, we were doing side jobs and we just got paid when he got arrested.
So do you own this house or rent it?
I'm in the process of owning it, but I've lost it.
It's in foreclosure?
Yes.
All right. Do you have any pets?
I do. I do. A little dog.
You have a dog?
Yes, sir.
Where's your dog?
At the house. I left it this morning.
Inside the house?
Yes, sir.
All right. I don't think that you're much of a flight risk. I think methamphetamine is a large factor here. I think it continues to be. You not no income. The person who which you made your income with is charged with methamphetamine charges and charged with beating you up pretty severely and choking you. He's in jail pending further disposition on those cases. You have no job, no real income, but you're not going anywhere. This warrant issued in March, or the incident occurred in March. It took a while for it to come back. The state police presented it to the prosecutor on May 17th. They authorized it on June 9th, and we authorized it a few days later. And there apparently was no urgency to serve the warrant because they waited from then until August 8th in the morning to serve it. You also have this issue of this abandoned car. Is that Ford Focus still on your lot?
No, actually that belonged to Mr. Leonard and the neighbor across the street. And he told me, he came over and told me he was gonna, because Rick was gonna buy it from him, never did. It got towed by the police department, and he came over and asked me if he could file charges against Rick for the car because it's gone now. That was all him and Rick. Had nothing to do with that, Your Honor.
Now okay, that's Mr. Leonard.
Yes.
All right. I don't really know what to do with you, Miss Briggs. One option is to leave you in jail until August 19th. I believe that you are currently struggling with methamphetamine addiction. I'm going to order you not use any controlled substance and take a test upon demand of any police or probation officer. No weapons, no assaultive behavior, and I'm going to set you for pretrial supervision. Under the direction of community corrections. Telephone numbers on here. I'm going to give you a PR bond under the understanding that you're going to show up for court. Will you do that?
Yes, sir.
You're currently the victim of a domestic assault that the case has been bound over to circuit court. There's methamphetamine all over in this. Back last year, they offered you a misdemeanor. You declined the misdemeanor, so they just dismissed the case. I don't know everything that went into that decision. It's called prosecutorial merit. I do know that you're a complaining witness on a pending assault with intent to commit great bodily harm case. You haven't gone anywhere. How much longer can you stay in your house? Have you got an eviction date or anything?
No, sir, I have, basically, I have two scammers fighting over it right now, so.
Well, you can't just stay there, so you're just waiting till the other shoe drops. You stop making the payment, you'll stay as long as you can.
Yeah. Because there's nothing more I can do on my end.
Do you have a driver's license?
I do.
Why don't you work?
I was working until Rick got arrested. We were
Well, that was
working.
months ago.
Yeah.
Have you ever had like a regular job?
Yep, I was working for the union doing the same work.
What kind of work?
Setting tile and terrazzo. And I just haven't done that lately because I don't have a vehicle right now.
All right, the fact you don't have any money is related to the fact that you don't have a job. So if I set a cash bond, you probably won't be able to make it. I don't like this because this is a methamphetamine case, and I think you can't use methamphetamine. I'm gonna let you out of jail, and you can't use methamphetamine, you can't use marijuana, you can't drink any alcohol. I don't know what you're doing. You've been just sitting in that house since March. There were needles, there were relatively large amounts, grams, I'll say, of methamphetamine. This is the time to start to deal with it. So you're gonna have to contact community corrections. It'll have to wait till Monday. And we're gonna have pretrial supervision. No contact with Richard. What's his last name? Joseph.
Leonard.
Have you been visiting him at the jail or anything?
No.
Right, you're not to have any contact with him.
No.
I suspect you don't want any, but sometimes strange things happen. All right, I'm gonna set the bond at $2,500 PR. Otherwise, you would just sit in jail. You're gonna get out of jail. You need to contact community corrections, and you need to contact your lawyer prior to August 19th. The last time the prosecutor just dismissed the charges, it's not likely they'll do that here. There's also the issue of this felony firearm charge, which could cause you to go to prison for 2 years. Also, I'm concerned about your dog being locked in that hot house. Have you got a ride back to Mendon?
No, I don't.
Is there anyone you can call?
There's a couple of people I can call, but I'm not, if I have to walk home, that's fine too.
No. Walk to the courthouse and I'll get you a bus pass, okay? come see the bailiffs at the front, up front, and they'll get you a bus pass.
Thank you.
All right. I don't know what to say, Miss Briggs. You're not in a good place. But being in jail is even a worse place. I'm gonna lay you out of jail and you're gonna start to detox from methamphetamine, which might be wishful thinking on my part. But as I said, there didn't appear to be any urgency in this. They waited a month and a half before they went out to arrest you. So $2,500 PR, no drugs, no alcohol, test as directed, no assaultive behavior, no contact with Richard Leonard, and you're to contact pretrial services for further direction. They may set up some testing for you. All right, you're good to go. Thank you, Mr. Stickley.
Thank you, Your Honor.
All right, that completes our day, I think.
All right. Mr. Lee, I've signed the order appointing Mr. Dukas to represent you in this matter so that you're aware. Okay, all right. So in this matter,
Except for a preliminary examination, I'm asking for a brief adjournment. I understand through timing with the court that Monday morning would be available. We could set it for that time.
All right.
Opportunity to go over discovery.
Will that work for the people?
Yes.
Preliminary,
We'll have witnesses present.
all right. So preliminary examination in this matter will be adjourned. Court finding good cause to do so. I will adjourn it to, what is it, the 11th?
Yes.
August 11th, 2025, 9 a.m.
Thank you, Your Honor. And, when the court's ready, I have a couple of matters put on the record.
Yes.
Your Honor, first and foremost, after the last hearing we were here for, the victim was present with a support person. As they were leaving the courthouse, they were addressed by someone who identified themselves as the friend of Larry Lee. I believe that person is now sitting in the gallery here today. I personally warned her, but I would appreciate it if we could repeat that on the record, that the victim is not to be talked to or contacted. I don't have anything indicating that Mr. Lee directed that contact, but I want to make sure everybody's clear so we don't have any further issues regarding contact with the victim of this case.
All right. And which individual are you referring to?
This lady right here.
Ma'am, if you come out this way, please. What's,
Hi.
hello, what's your name? Yeah.
Hello, Your Honor.
What's your name?
I'm Jeanette Thompson.
What did you want to tell me?
Okay, so just to begin here, I'm very respectful. I don't know nothing that happened. When the I believe it's the victim was walking out, he was staring at me and I'm with 3 different women. And since he was staring at me, I said, are you so-and-so? I could identify him. So I think he was just irate because of what he going through. I don't know. But to be honest, I don't know that man. When he was talking, he was using verbal language. He walked back towards me and 3 other women and was kind of upset. And I said, I just want to know if you okay. My bad. I could identify him. That was all it was. I said, I just want to know you okay. I don't.
Okay, so just stop you right now. Yes. So I don't want you to have any contact with the this case whatsoever. It doesn't matter if you are worried about whether or not they're doing okay or anything along those lines. You just not to have any contact, because ultimately, while the people don't have proof that Mr. Lee's involved with that, it could be attributed to him in regard to behavior, and I don't think you want that to occur. All right. So I don't want any contact whatsoever. Am I understood?
Yes, sir.
All right. And if I do find out there is, at minimum, I would have you report.
Well, please, can you tell him not to walk up on me
I'm
again?
not gonna tell him that.
Okay, because that was
You are, well, hold on. He's here as part of a court procedure.
right.
You are not.
Correct.
So you need to, if it's necessary, you need to get out of his way. There's court security if that becomes an issue for you.
Okay.
Or you can just make the election that you do not need to appear. If you want to see the proceeding that is happening with Mr. Lee, then certainly you may view that on YouTube. So there isn't a reason for you to be here. There is a reason for him to be here.
Got it. Okay.
Understood?
Yes, sir.
All right, thank you. You can have a seat.
Thank you, Your Honor. One other thing regarding the discovery request, that Mr. Lee said he had sent one to our office. I just received the email. It was labeled a FOIA request, so it went to our appeals and FOIA department. It appears it's a mix of, and I'll make sure to share this with Mr. Drukas, but essentially, it appears he is attempting to FOIA communication that I may have had with the court, that I may have had with Mr. Burgess. There's also a grievance / investigation request looking to, it appears, grieve me. Potentially more people. I haven't read through the whole thing. Somewhere in there's mention that he wants anything related to this case, but the overall idea and heading is FOIAing all communications that have happened in this case, as well as attempting to grieve myself and potentially other people. So I know at this point, Mr. Drukas is appointed. He'll get all the discovery. We've been in communication. I've asked our office to expedite the video discovery to him. I handed him a report that's unredacted, but it is the full police report. So we'll take care of that. But perhaps there should be a conversation Mr. Drukas wants to have with Mr. Lee about the rest of it and anything that may or may not be brought up as part of this case, and that the grievance process is a separate process, which he is entitled to.
Right. If that's what he wishes to do. All right. Any other moment? All right, very good. Thank you, folks.
Thank you.
Everybody have a great weekend.
Thank you.
Bond will continue at this time. We'll see you Monday morning.
Whatever case it is that has you in the Department of Corrections?
3 months. 3 months.
Pardon me?
3 months and a half.
3.5 months?
Yes, ma'am.
Okay, are you in on a probation revocation or what got you in?
My charges got me here, but it's probation revocation.
Okay, got it. All right, what I'm going to do in a moment, Mr. Williams, is put you in a breakout room where you can speak privately with Ms. Wood, and she just wants to cover a couple things with you, and maybe we can wrap up your cases today, but if not, we'll at least start the process of moving towards trial or whatever is going to happen with your cases. So sit tight, and let me just see if Ms. Wood has any of these next few. Position 3 is Calvin Andrews. Ms. Wood, is that your?
That's Miss Rios, Judge.
You're right. Okay. You have both of Mr. Williams's because the older case has that lower number.
Yes, Judge.
All right. We will come back to position 3. Position 4 is Jairus Talbot. Hey, Mr. Talbot. I don't know if Ms. Cabrera is online. We got a lot of people online. Have you? Oh, no, because you need to hire a lawyer.
Last time I came, you all told me that a lawyer will reach out within a week or two, and I left multiple voicemails on, I guess, the DA's office voicemail, but haven't heard anything. I came up here the other week, last week, told someone to reach out, but still haven't heard anything. I don't really even know too much about this case.
Yeah, that's what everyone in this case seems to say. It's an interesting case. CSX. Yeah. So there's a lawyer listed who would be one who's appointed to represent you, but I also have this note here that said we're resetting it. Have we met before? Did you come the very first time?
Yes, we came.
And did you say, no, Judge, I'm gonna get my own lawyer. I don't want you appointing one.
You did, and he made me write down my information, and he told me to give it about 3 weeks.
Okay.
And when I came here, I had the same conversation.
All right, I'm not doubting you. Ms. Nelson, do you have anything more in your notes? Because Mr. Talbot seems pretty clear that he wasn't planning on hiring a lawyer.
No, Judge, and I will reach out to Miss Euphemia and check with her.
Okay, so if you take a seat, we'll see. There's a lawyer who was appointed to represent you, but somewhere in the system, we thought that's not what you wanted. You were going to hire. Are you working?
I'm really.
Okay. Realtors typically don't get appointed lawyers. Are you a successful realtor or you wish you were a successful realtor?
Well, I'm successful, but I just started out 3 weeks.
What were you doing before you were a realtor?
Business, contract, Home Depot, and Lowe's.
And how did that business go?
Great.
Okay, so why would we be supplying a taxpayer-funded lawyer for you?
Because that business ended and I actually missed something else. So
Okay,
it's time to be.
so times are tough right now, but when you were in the box truck business, things were good?
Yeah, I mean, it was, until it wasn't. I mean,
Okay,
I love that. Everything got messed up with that, especially with this case.
okay,
Yeah, that cost a lot.
all right. Take a seat then, and we will see if we can get Ms. Cabrera on. I'm going to move you, Mr. Williams, into the breakout room now, and we'll see if you two can talk. Let's see what happens here. There's one, and there's two. Look at that. Ms. Rios, you have position 3, which is Calvin Andrews.
Not had contact with Mr. Andrews.
Neither have I. Ms. Davis, bench warrant?
Yes, Judge.
All right. We just talked about Mr. Talbot. We'll come back to that. Layla Faria, I apologize if I'm mispronouncing your last name. How do you say your last name? Faria, excellent. Good afternoon. Is 0 you or is 0 Ms. Wood?
Ms. Wood.
Ms. Wood, okay.
But it looks like it's conflict because it's Sydney Gibson. I believe she's with the conflict office.
Oh, okay. Do you have a lawyer? No. Do you need a lawyer? As in, were you planning on hiring one or do you need, you do need a lawyer is the answer?
I found out last minute that I have course,
Okay. You feel like you can afford an attorney?
at the moment.
Okay. This happens a lot when Sydney Gibson's name is listed, that then there's no one here. I'm not faulting her because I think she handles things pre-trial.
Yes.
Oh, this is this case. No, it's not. It's just one with 3 defendants. Oh, do you have, Ms. Wood, have one of these? Princeton Hines would be you guys?
Hold on one second.
It's three co-defendants.
It's 3. Trying to see if she would have one of the, who was from our office. Oh, yes, Princeton Hines is with our office, so she must have.
Mr. Lewis.
Yes. Oh, she does have Mr. Lewis. Ms. Wood did tell me about this case.
Okay. Yeah, he's online, so we'll get him in a minute. All right, so Ms. Faria, if you take a seat, we're gonna do a little exploring to see who your lawyer is, okay? How about Isaiah Gates?
No, yes, sir.
All right, Mr. Gates, and how about your lawyer? There he is.
Present, Your Honor.
Hey, Mr. Walls, how are you?
Good afternoon, Your Honor. I'm doing well. How about yourself?
I'm okay. Did we confirm Mr. Gates's situation? He's not going to come into the courtroom. Okay. All right. And that's a situation flowing from your team, Ms. Simpson. Okay. Mr. Walls, got to cover 2 things here. First, are you waiving arraignment for Mr. Gates?
Yes, Your Honor. I filed waiver about 12:30 today, and it was accepted in the Odyssey.
Great. It may not be visible yet for me, but that's good to know. And yep, it's in. So you've done a waiver. Mr. Gates, you are out on bond. Let me see what your bond order says. You're supposed to stay away from your co-defendants. That's pretty much it. Hopefully, that's not an issue for you. Did you get something in the mail today, Mr. Gates, telling you had court?
No, sir. I got something in the beginning of the week.
I didn't ask that. Well, did you get something in the mail that may not have come today?
Yes, sir.
Okay. You live on Sonoy Road in Fairburn?
I do, but I need to change the address. I just moved recently a week ago, if not 2 weeks ago.
Okay. I need you to get your new address to Mr. Walls so he can do a change of address for you, okay?
All right.
Does Mr. Walls have all your other contact though? Cell phone, email?
He does.
All right, so he can keep you posted. Mr. Walls, by the entry of your waiver, I will get a scheduling order out, which gives the state a deadline to get you the discovery, gives you a deadline after that to file motions, et cetera, and we'll be off and running. There is one little wrinkle for Mr. Gates. Mr. Gates, I am being told that there is an active warrant for you, and you need to address that because it's going to sneak up on you otherwise. It's with probation. Are you on probation right now?
I am, sir, and I just came from doing a revocation for them for this charge.
When you say you just came, when was that?
That was, I believe, April. That was April.
Okay. Ms. Simpson, you have something more recent than that? Or maybe the warrant wasn't cleared from the system?
I believe it wasn't cleared from the system.
Okay. I'm glad you believe that. We need to make sure what's really going on. I just don't want you make a left turn where you shouldn't, and all of a sudden what would be a ticket is you're cuffed and you're going to jail.
Okay, yes, sir.
What jurisdiction are you on probation?
Gwinnett.
In Gwinnett? Okay. You say it was processed? Oh, that's when he said he had his hearing. So it may just be lingering in the system. Should he reach out to his probation officer? Okay, Mr. Gates, we can't solve this problem for you because it's a Gwinnett thing, but you or Mr. Walls should reach out to your probation officer saying, hey, I'm hearing there's still a warrant in there for me. Didn't we take care of this? And they need to clear it up because if you did take care of it, that warrant needs to go away. But Gwinnett is the agency that has to make it go away. Okay?
All right.
All right, Mr. Walls, anything else on behalf of your client?
No, Your Honor.
All right, we'll be on the lookout for that scheduling order and we'll go from there. Oh, wait, let me make sure. Ms. Davis, anything from the state? Okay, that's it. You guys are free to go.
Thank you, Your Honor. Have a great weekend.
You too. Happy Friday.
Happy Friday.
Right. I just need his lawyer in here.
Ms. Wood is back out of the breakup room because there was a disconnect but she filed a waiver number 6.
For number 6, we still need to talk.
Oh,
Hey, Mr. Lewis, can you turn your camera on, please?
Yes, sir, I'm here.
Good afternoon. I'm Judge McBurney. Were you maybe listening in while I was talking with Mr. Gates?
Yes, sir.
So you're in the same situation. You have an active probation warrant. Did you know that?
I was not aware of that, sir.
Have you been to court recently to deal with probation?
No, sir. I haven't heard anything from probation. I wasn't aware of that.
Did you know you were on probation?
Yeah, but I haven't heard from them since I got out of prison. I only went and seen them one time and then I never heard from them again. I was never able to get in contact with my probation officer.
Well, there's your problem. Okay. What county are you being supervised in?
Cobb.
Okay. Well, they think you haven't been in touch with them. You think they haven't been in touch with you. They always win that argument. So there's a warrant for you and you're going to want to clear that up. But let's focus on this case. Ms. Wood, this is Mr. Lewis. Looks like you filed a waiver of his arraignment.
Judge, I don't know if I actually went ahead and submitted it. I connected with him this morning, and so I am filing a waiver on his behalf, Judge. I do have contact information for him now, and yeah, I'll be looking forward to getting discovery on this case.
Okay, so you will do a waiver. That'll get your name in there instead of Princeton Hines. That'll get you discovery. That'll move the case along. Mr. Lewis, you can talk with Ms. Wood. So he's got your number, Ms. Wood, because it sounds like you connected this morning.
Yes, Judge.
All right, well, you guys should talk. Ms. Wood doesn't practice in Cobb County, but she has colleagues there or people she knows there. You're going to want to connect with probation. If you get pulled over for running a red light, you're going to end up going to jail, not for the red light, but because there's this warrant sitting out there, okay?
Yes, sir.
All right, hate to be the bringer of that bad news. I had nothing to do with it, but you certainly want to clear it up. Ms. Davis, anything for the state?
No, Your Honor.
All right, any other questions, Mr. Lewis?
No, ma'am. No, sir.
Okay. Ms. Wood, anything else?
No, Judge, thank you.
All right. You're free to go, Mr. Lewis. Stay focused on probation.
Yes, sir.
Ms. Wood, Ms. Rios told me there was some technical hiccup with Mr. Williams. Is he gone or is he back?
He's back, Judge. It looks like they're on a different device now.
Okay. Did you and he complete the discussion or do I need to get you guys back in the breakout room?
I need another breakout room, Judge.
Okay. I'll do that in a minute. I want to press a little further through this calendar and then we'll let you guys talk. All right, Mr. Talbot, Ms. Cabrera does represent you. I'm going to give you her phone number and she's filed a waiver of arraignment on your behalf. So you need to reach out, just meaning she entered a plea of not guilty on your behalf. Probably what you want to do. Okay. I'm going to get you her phone number and her email address. You can reach out to her. Okay. And once you get that from Deputy Gordon, you should feel free to go. And so, you know, in your case, 2 defendants have pled guilty. The third one, who is in state prison, is going to be pleading guilty as well. Doesn't mean you have to do anything. I'm just letting you know what's happened in the case. You're the last man standing. You and Ms. Cabrera will talk about it. Made me nervous standing there. All right. Charlie Daniels. Hey, Mr. Daniels. You're represented by Mr. Majeski? Any idea where he is?
Judge, he filed a waiver. The parties were excused.
Okay, your lawyer filed a waiver of arraignment on your behalf, just meaning he entered a plea of not guilty. And my staff, that voice you just heard, that's Ms. Nelson, she told Mr. Majeski that you and he were excused. So he should have let you know that. It's good you showed up. I'm glad you're here. Yes.
They're incarcerated, so my fiance passed, so I don't have his key number.
Okay.
I have my contact.
I'm going to give you his phone number in just a second.
And Judge, if you need some help, I can relay that information to him and I can call Mr. Majeski if you need me to.
And this was?
This is Attorney Mike Barber. I apologize.
Oh, all right. Great.
Help the court.
There he is. All right. Thank you, Mr. Barber. Do you want to, why don't we do it this way? Why don't you give Deputy Gordon, Mr. Daniels, the best way to reach you, phone number, email address. He's going to give you a card to write it down. I'm going to pass that to Mr. Barber, who will get that to Mr. Majeski.
Is Deputy Daniels, he's in court or is he on Zoom? I assume he's in court.
Mr. Daniels is sitting in court, writing this stuff down right now.
Let me give him my phone. It's if I can, Judge, or do you want me to give it through the chat?
No, you can give it to him in just a sec. He just needs another card to write that down on.
Yes, Judge.
We're going to run out of cards. Mr. Daniels, do you still live on Wyndham Way? Okay, so that's a good address. We'll be mailing things there, but Mr. Majeski will always get the info as well. Are you ready to write down a phone number? This phone number is for Mr. Barber. That's not your lawyer, but it's a friend and colleague of Mr. Majeski's. But that way you've got a number to call and he can give you more information about Mr. Majeski, okay? We're ready, Mr. Barber.
It's 404-445-8494, Your Honor.
Great. 8494?
That's correct.
Okay, and I'm going to send you a text, Mr. Barber, that is Mr. Daniels' phone number, if you will do your best to get that to Mr. Majeski.
Of course. I can absolutely do that.
Thank you for being the intermediary. All right, done. So Mr. Daniels, you're good to go. You've got info on Mr. Barber, not your lawyer, but friend of Mr. Majeski, and Mr. Majeski is about to get your phone number. All right, see you around. Tylea Woodson. Hi, Ms. Woodson. Pardon me? I'm okay. How are you? Good. Ms. Rios, your client?
Yes, Your Honor.
Have you all spoken?
Yes.
Great.
I filed a waiver, but we do need to address her ankle monitor.
Okay. Is this something Ms. Davis knows we're going to be talking about, or you want to talk about it anyway?
I filed a motion. I thought I included you in
This is
this.
a DPK judge.
Oh,
Okay, I'm gonna try.
okay. I'm fine talking about it. I just need to make sure there's a prosecutor who is ready to talk about it as well. And sometimes that involves reaching out to the alleged victim in the case. But in terms of the arraignment part, you filed a waiver, so that'll get that moving forward. We can talk about bond once we figure out who the lawyer is handling the case for the state. Let me ask you, Ms. Woodson, a question, since I got you right there. Are you still at Commerce Drive, an apartment? Okay, good. So we've got a good address for you. And then the one condition that you want to talk about is the ankle monitor condition, Ms. Rios?
Yes, Your Honor.
Okay. Which has been on now for 8 months, nine months. Pardon me?
245 days ago.
Not that you're counting? Okay. Is it one that the county is paying for?
Yes.
Okay, so it's free, but you got a big old box on your leg.
Yeah, and the problem is that
Well, I'm gonna let you talk about it. We just need to figure out who the lawyer is for the state, okay? Malik Lewis is who you're supposed to stay away from.
I'm under the impression from the last judge that it was just no violent.
Oh, you're right. It does say that. It says no further violent contact. What was the ankle monitor for?
I'm not sure. She literally just put it on me and told me that, like, I don't even have any conditions with it on her. I can go anywhere, do anything. I just have it on me.
Interesting.
And
And you're still wearing it?
Yeah, it's on.
Okay. All right. But you're not enjoying it.
No, not at all.
Okay. I haven't seen a bond like this before. Okay. So this would be Ms. Willingham.
Judge, I'm texting her now.
Okay. All right. Ms. Woodson, if you'll take a seat, we will address this today. Because even if the prosecutor can't get here, she can certainly communicate to one of the prosecutors here to say, hey, here are my thoughts about it.
Okay.
All right.
It was my fault. I emailed the wrong prosecutor. I let them know about.
That's okay. We'll see if we can work through this. And now into the case with so many defendants. Mr. Bradford? How do you pronounce your first name? Quadir Bradford. Good afternoon. How are you? All right. Do you have a lawyer?
Yeah.
Who is that?
I don't know.
Well, I thought you said her. Oh, why did you think a lawyer would be here today? Okay, who told you a lawyer would be here today?
Judge,
Ms. Wood?
I'm going to interrupt. I'm sorry to interrupt. This is the gentleman who didn't have a first appearance and I stepped in, but Ms. Rios has the co-defendant. So I did tell him I was hoping that there would be an appointed attorney for him there today. So.
All right, which of the many defendants does your office represent?
Patterson.
Tyrone Patterson. Okay. So we need the conflict defender's office to go into overdrive because assuming people showed up, there are going to be a bunch of people here with no lawyer.
That's correct, Judge.
Okay. All right. Stay right there. So Ms. Rios, you have position 15. All right. So Mr. Bradford. Let's get into this case. How did you know to be here today? Did you get something in the mail or that mystery voice we just heard told you to be here? Pardon?
Yeah, she told me to be here.
Okay. Do you still live at Braylorn Court in Stone Mountain? Okay. Did you get anything in the mail telling you to be here?
No, but I had booked. She told me to be here on the 8th to meet
with a lawyer.
Yeah.
Got it. And that was the right advice. And the hope was that there is a system that appoints lawyers when there are multiple defendants, because you can't have lawyer from the same office as someone else in the case, because they need to be able to represent you independently of anyone else in the case. And for whatever reason, this case has 1 million defendants. So we need to get you a lawyer, and we will do that. But it's not going to happen right now. So you will get something in the mail telling you when you need to be back here. Ms. Wood, do you have additional contact information for Mr. Bradford that can be forwarded to whatever lawyer is appointed to represent him?
Yes, Judge, I've spoken to his family quite a bit.
Okay, excellent. Do you have a cell phone? Does it end in 6167? Yes? Okay, so it sounds like there may even be a phone number in the system that can get to that lawyer. So we'll work on figuring out who your lawyer is going to be. You may want to check in. If it's been a month and you haven't heard anything, you may want to call my office saying, what's going on? Okay? Anything else? Okay, well, I appreciate you being here when you said you'd be here. You're good to go. All right, same case, different defendant, Raheem Smith.
Hi, good afternoon.
Hey, Mr. Smith, how are you?
I'm fine, yeah.
I'm all right. Do you have a lawyer?